There we go. Stuff is glitchy this morning. Let's try this again. Good morning. Happy Tuesday. Welcome to the Courtroom Files Live. Apologies for being a couple minutes late. Let's start our day with Judge McNally, and let me figure out why things are glitchy.
Your names?
Zorn Zarowski.
Lisa Zarowski.
Okay, so I'd like to see your proof that you were at urgent care on May 20th, Mr. Zarowski.
I didn't go to urgent care. I apologize.
You lied?
No, I didn't lie.
Well, this is what I wrote down. I wouldn't write this down. So Lisa Zarowski failed to appear. Dorn called, said he was on way to urgent care. Rescheduled Dorn for creditor's exam. Defendant to bring proof he went to urgent care this morning.
I didn't.
Hang on. Lisa, issue show cause. Why'd you tell us you went to urgent care?
I told her I was going to go to urgent care as soon as my wife got back. My wife ended up getting a golf tee stuck in her tire and stranded at her mom's, so her brother changed the tire.
Why did you tell us you were going to urgent care?
Because I planned on going to urgent care. I didn't end up going.
You didn't need to
She
go.
didn't get back to about 1 o'clock, 1:30.
You didn't-
Actually, after
hang
the
on.
kids got out of school.
Why didn't you show? Oh, I got it. Oh,
So
the,
the bridge was
the
closed.
T in your tire?
Yeah, when I was driving down
Tea.
Meridian to take the kids to
Did
school.
you take it somewhere to get it fixed?
I have a picture of
I
it too.
did.
Hang on,
I did.
hang on. I'm just talking to one person at a time.
Yes, we did get it fixed.
Hang
but
on,
not that
hang
day.
on. Where'd you get it fixed?
Mr. Tire on 4th Street
When did you get it fixed?
the next day. I had to go get a new tire.
Did you bother calling Ms. Zarowski and telling us that you weren't gonna be here?
No. I
Too
didn't.
much trouble to call and tell the court when she showed up?
No, I didn't.
Folks, this is not a game. You were subpoenaed for a creditor's exam. I have a good mind to lock you up. You start telling people you're on your way to urgent care. On way, that's what it said. I wouldn't write down on way. You told them you were on your way to urgent care, Mr. Zarowski. Don't do this. If you think you're gonna come in here with stories with me, you better find some other judge in some other court in some other country. I wanna know why you didn't call, Ms. Zarowski. So I got one person calling lying and the other one not calling. That's what we have here. This is a courtroom, ladies and gentlemen. This is not a bar. I just am amazed. You know, maybe it's because of my upbringing. You know, almost 100 years, my family's been in this profession continually, and I'm just amazed by the number of people. But you guys are not proving to be on the lighter end, you're proving to be on the top end. I'm amazed how many people have such little respect for the greatest institution in this country. There's none better, not even close. Not even close. I don't know what I'm gonna do. I don't know what I'm gonna do here. I hope you brought all the documents she requested.
Yes.
So I want to make sure you have your last 2 pay stubs, last 2 bank statements, you have your 23 and 24 tax returns, social security cards and vehicle titles, right?
I don't have the vehicle title.
Why?
I can't find it.
Go to the Secretary of State and get it. You had plenty of notice. This was sent April 10th.
Or is it in here?
Hang on. Can't find your vehicle titles? What'd you do with them? I mean, really,
Because we moved since I got that vehicle.
what kind of vehicle do you have?
It's a 2006 Ford Explorer.
And what, you left it in your other house or apartment or wherever you lived?
No, it's in either in storage or it could be in here.
Could be in here. You were ordered to bring it, but you don't take orders very well because you were supposed to be here for that creditor's exam.
I have it online.
Listen. I don't think you get it. I don't think you've ever gotten it. Do you realize these are court orders? This isn't a request, a suggestion. Nobody's sending you an invitation to a birthday party here.
Yes, I've never missed a court date in my life.
You did that day,
Yeah,
and you lied to us on top of that. You said you were on your way to urgent care. I don't know, maybe it isn't out there yet, but I'd like to think people know that I'm not a game player and I'm not playing with you. I don't know what I'm gonna do. I'll probably issue a show cause and we'll have a contempt hearing. But in the meantime, I'm gonna send you folks back for a creditor's exam. And Ms. Gonzalez, you're gonna be free to ask them any questions. And then you are all coming in here. All of you are coming in here and I'm gonna make sure that everything was taken care of and they answered every single question that you asked. Now, I want you, Mr. Zarowski, and you, Ms. Zarowski, to raise your right hands. You solemnly swear affirm, under penalties of perjury, that the testimony you will give in these proceedings will be the whole truth. So help you God.
Thank you.
So let's see here. I'm gonna trust. So you got a judgment for $13,137.02. I reduced it by the security deposit of $37.50, that leaving a balance owing of $93.87.02. Have you received any payments?
They paid $5,500 and then just one.
I'm gonna let you guys go to, he's gonna take you to a conference room. Again, I wanna make clear, when you're done, everybody's coming in here, back in. If there's one thing I can't stand, it's people lying here. You don't lie in a courtroom. You want to go tell fish stories? The salmon that you yanked in was 48 inches instead of 19. That's your business. If you can live with telling your friends that, but you do not come in here and lie. Go do the creditor's exam, and then I'll see everybody back here.
So Dad's a little cranky this morning. Good morning once again, everybody. Welcome to the Courtroom Files Live. We were 2 minutes late and a little bit glitchy, but I've solved the problems of the glitch, and I apologize again for being a couple minutes late. The pre-show ran a little long today, but we had fun. So if you're not joining the pre-show, you should become a member and you should do it because we laughed. Laughter is good. Let's go to Florida. Wade Mercer doing first appearances.
Kenny, good morning. It looks like you've been sentenced on local charges, but you have a warrant out of Washington County, violation of probation warrant. Corporal, this warrant appears to be an ROR warrant. Is that what you're showing also?
Yes, Your Honor. First main housing place.
Yes, sir. So he's still finishing a sentence here, correct?
Correct. Yes, sir.
So, Mr. McKinney, you have an ROR warrant out of Washington County for allegedly violating the terms of your probation. An ROR warrant is released on your own recognizance. So the judge over there does not want you held. He wants you to be released.
Reporting the probation, John.
Yeah, to report directly to probation. So what that means is when you're released, you need to report directly to the probation office. If you're released on a weekend or after hours, which you shouldn't be after hours, but if you're released on a weekend or a holiday, you need to contact them immediately. You should have a phone number for an on-call officer that you were given when you got probation sentenced, when you were sentenced originally. But you will not be held for them. You'll be released when you finish your Jackson County sentence, but it's your responsibility to turn yourself in over there or report in at least. Any questions?
No, sir.
All right, have a good day, sir. Dylan Courtroom, you don't have another copy of that via first appearance sheet, do you? I need two of them because I have one for the media sheet. Thank you. Mr. Corbin, good morning. Mr. Corbin, you're here because you've been accused of one count of driving under the influence. Mr. Corbin, there is probable cause for that charge. Sir, I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney.
Yes, sir.
Your Honor, I spoke to Mr. Corbin. He's in a plea of no contest. The charge is listed. The understanding he'll be sentenced to 1129 probation, early termination, possibility 1,078 fines, 50 hours of community service, minimum driver's license suspension, AA classes, if directed by probation, and a DUI class also. He has waived his right to a jury trial and call witnesses.
Thank you. And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Corbin, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement?
No, sir.
Mr. Corbin, is that the plea that you would like to enter to resolve this charge?
Yes, sir.
Mr. Corbin, I'm going to accept your plea of no contest to the charge of driving under the influence. Sir, I'm going to judge you guilty of that offense. I'm going to sentence you to 11 months and 29 days probation. Mr. Corbin, you will have the standard conditions of probation plus the following special conditions: $1,078 court costs and fines, successfully complete substance abuse counseling, 50 hours of public service work, DUI school. I do recommend the minimum driver's license suspension. If you choose to do AA instead of a private counseling, we're going to put a cap on that of 12 classes. And Mr. Corbin, if you enroll in your DUI program within 60 days, that will constitute and satisfy the counseling condition, because that's a 16-hour course they're going to make you go through in the DUI school. If you don't enroll with that within 60 days, you got to do separate counseling. Mr. Corbin, they're going to let you use the phone at the jail to contact friends or family for transportation. Then they're going to bring you to the courthouse because the probation office is at the courthouse. When you get here, you'll meet with Mr. Ham. They'll go over the terms of the probation with you. They'll give you a chance to ask questions. They'll give you a copy of all the rules in writing, and then you'll be free to leave. So if you contact friends or family, Mr. Corbin, you can tell them that you can be picked up at the courthouse in roughly 30 to 45 minutes. Mr. Corbin, any questions?
No, sir. Thank you.
Have a good day, sir. Yes, sir. It's enrolled because they may not even have a class that's completable in that time period, but may not even have a class he can get in that time period, but he can at least be enrolled. Ms. Banks, State versus Tower Banks. Ms. Banks, good morning. You have a failure to appear warrant in case 23-480 CF. Ma'am, it's a no bond warrant signed by the circuit judge, Judge Garcia, and it says failure to appear at pretrial conference. So Ms. Banks, what that means is you're going to be held until you can get back over to circuit court and try to get this case against you resolved. I'm going to ask Mr. McDaniel to notify your attorney if you receive one, and I'm sure you have at this point. Notify your attorney that you're in jail with no bond, and typically that's going to trigger the attorney to come see you at the jail. Ms. Banks, do you have any questions?
No, I won't know when my court date is until he comes.
I can tell you the next pretrial date probably, and this will likely be your court date. I can't definitively tell you that, but Judge Garcia's next pretrial date is going to be, looks like it's probably going to be August the 19th, but the attorney may tell you a different date possibly when he or she comes and sees you. Okay?
Okay.
Have a good day.
Thank you.
Ashton Petty. Mr. Petty, good morning. Mr. Petty, you have a holdout of Bay County. It appears to be a violation of probation allegation over there with no bond. You're going to be held for them until they can get you over there and get this allegation resolved. Mr. Petty, I try to tell people a rough timeline of when they're going to go. It could be today. It also could be later this week. Today is what? What's today? Tuesday?
The 15th.
It's probably going to be this week. I can't tell you specifically when, but you can be over there the next few working days. When you get back over there, you'll go to a first appearance there. And at that first appearance, that judge will address your bond further. They may or may not modify it, but right now you have no bond. Any questions?
Yes, sir.
Have a good day. Charles West. Mr. West, good morning. Mr. West, you're here for first appearance, sir. You have looks like you were held for Holmes County, and now they have a no bond warrant for violation of probation. I'm looking at a copy of it signed by the circuit judge. So, Mr. West, you got no bond over in Holmes. Your situation is similar to Mr. West. It's similar to Mr. Petty's. Got no bond until you can get over there to Holmes County to try to get this allegation against you resolved. Should transport you in the next couple of days. Any questions?
No, sir.
Have a good day, sir. And we completed our first appearances. We started at 8:30. So if you missed a case, you ask me what case it is, I can tell you what happened. Dylan Corbin entered a plea of no contest to the charge of DUI. He has almost no history, had one minor misdemeanor or something years ago. He was sentenced to 11 months and 29 days probation, which is a standard first offender DUI sentence. He's got the standard conditions of probation, like no alcohol, court costs and fines, reporting into a probation officer, possible early termination. I don't know if I said that or not, but there's possible early termination. So that means he might be able to get off in 6 months. Is he still in the room there?
No, he's out.
No, Your Honor, he's outside on the phone.
Okay, are you his? Will you let him know, please, that his mother is here, that she came in after we did his first appearance and plea? That maybe he's trying to call.
Yes, Your Honor.
So thank you, Corporal. So ma'am, what all that means is he'll be brought to the courthouse in roughly 30 or 45 minutes because that's where the probation office is at. He'll meet with Mr. Ham with the probation office. Once he meets with Mr. Ham will go over the probation with him. He'll show him, tell him everything, all the rules. He'll give him a copy of the rules in writing, to give him a chance to ask questions, and then he'll be free to leave. So he can be picked up from here in 30 to 45 minutes. Do you want me to ask him to tell him that you're going to be able to pick him up? So Corporal, when we get through, if you let him know that his mother is going to be able to pick him up, she'll be here when he gets here 30, 45 minutes from the probation office. Probation office is on the first floor on the east side of the courthouse. Inside the county judge's office is where the county probation office is at. Any questions, ma'am? All right. So I think that's everything we had this morning. Mr. McDaniel, anything else from the public defender's office?
Nothing else, Your Honor.
Thank you. Corporal from the jail.
No, Your Honor.
And Mr. Mitchell from the state.
Nothing but state, Your Honor.
Did y'all get an email yesterday about Thursday and Fridays?
Yes, Grover Thursday, Taylor Friday.
So I think both of them will have their own assigned first appearance team that they work with. So y'all will have that first appearance morning free. All right. Thank you, ladies and gentlemen. That concludes first appearances. It's 8:38 and court's adjourned.
Okie dokie. Let's go over to Louisiana. Let's see if we have a winner or a loser today.
I will be your acting chair today. Along with me, to my left is Mr. Ledoux. To my right is Mr. Byra. Would staff at headquarters please introduce yourself? Okay. And would staff at Louisiana Correctional Institute for Women please introduce yourself?
Kristen Thomas, Warden.
Tara P, manager.
Acting Gaddy, Supervisor.
Okay.
Here it is.
And we're here today to hear the case on Miss Sharon Roberts. Ms. Roberts, state your name and DOC number for the record, please.
Sharon Roberts, 11/19/55.
Okay. So today we're here for her parole hearing. Her parole date was 10/17/22. Her discharge date, good time date is 10/10/32. Full-term date is 8/29/33. She is a 5th felony offender, and she is serving 31 years, 5 months, and 13 days for the charges of manslaughter, simple arson, and aggravated arson. Does that sound correct, Ms. Roberts?
Yes, sir.
Okay. Before we get started, just a little bit of house cleaning. You know, we have a lot of people here today. I am gonna try not to cut anyone off. I know everybody has a lot to say. So, but try to keep your comments brief if you can. If you can't, we will bear with, sure. We want you to get everything out that you came here to say. Okay, first off, Ms. Roberts, tell me why you think you should be considered for parole today, and what did you do to get in jail?
Mr. Freeman, if I could just quickly interrupt, sorry, Micah Sloan. I'm an attorney representing Sharon Roberts. I'm an attorney with the Louisiana Parole Project. Ms. Roberts does have some intellectual deficits that make it difficult for her to fully express herself and to articulate. But it was really important to her that she get across to the board her feelings of remorse. And what she's done is she's written down a letter expressing that. And I wonder if the board would allow her to read that letter before we begin questioning. I know she would appreciate that opportunity. I think it's important that it be in the record.
That's no problem. I'm sorry I missed you, Ms. Sloan.
No problem.
And you can help her out anytime you want during the hearing,
Thank you.
okay? I will get to you for your statement also at the proper time.
Actually, so Ms. Roberts has two attorneys today, and I'm gonna allow Ms. Hannah Rose Gordell to do this statement later. But I'll be here if she needs any support.
Okay, all right, Ms. Roberts, read your letter then, if you would like to.
To the Gaspard family, I'm sorry that I caused the death of your mother. There's not enough words to explain the remorse I feel for my crime and the pain and suffering I've caused your family. I was wrong for doing this, causing Amy's death, and I'm ashamed. Every day I think about the loss I have caused you. I wish I could turn back the time and change what I did. I hurt for you, all of you. And even though words would never be enough to accept for what I did, I am really sorry.
Okay, all right, Ms. Roberts, well, tell us, why do you think you should get out today?
For the past 23 years, I accept, what I did, I was wrong. I'm an alcoholic and I went through programs. I did a lot of schooling. I got back my education back. I did my schooling. I did AA. And I'd like to continue doing my AA, substance abuse, and seeing a social worker. My actions, what I did was caused by the death, Amy Gaspard.
And what did you do? I mean, how did this happen?
Because I was involved, I was drinking, and I was involved with drugs with another acquaintance that would come over, and I would leave and get drugs for him and leave and get alcohol and come back and get more pills to sell so I could get alcohol.
Okay.
And I threw a cigarette on the floor and just left it there. But I never thought it would get out of hand.
Okay, we'll get into that. Your case was assigned to Mr. Barra. When it's his time for questioning, we'll get more involved into the exact incident. Okay, now we're gonna hear from your supporters, Mr. Andrew Hundley of the Parole Project. Mr. Hundley.
Andrew Hundley, representing Louisiana Parole Project, to inform the board that if Sharon would be granted parole, that she is a client of our organization and we would accept her into our reentry program. Just a few notes on why we accepted her. We recognize and are well aware of her criminal background. However, due to her age and her demonstrated maturity over the last 20 plus years, we are impressed with the person that she has become and have confidence in her ability to transition if given a second chance. She has no disciplinary offenses in the last 13 years. So she's demonstrated that she could follow rules. And she has had an array of programming that she has continued to take on even to this day. She served over 2/3 of her sentence at this point, and because of changes in the law, this could be her last parole hearing before good time discharging. So we asked the board to consider that she could, now's an opportunity for the board to grant her release with some conditions before she has an eventual good time discharge. If she would be released to our program, our staff social worker, one of our staff social workers, Audrey's here to tell you about the interviews and the plans that our social work team have made with her around her sobriety and other mental health issues, and that we're prepared to offer her if she's released. But she would be a long-term client in our residential reentry program. We would help her find employment and start working towards long-term self-sufficiency. In short, our organization has great confidence in her ability to come home, and we're standby invested with skin in the game to ensure that she has the support she needs to be successful if given a second chance. And I stand by to answer any questions you may have about her reentry. Thank you.
Okay, thank you, Mr. Hunley. I just want to note for the record that we have Mr. Hunley, he's with the Parole Project. We have Miss Audrey Barton, she's a social worker. She'll be giving us, she'll be speaking next. Hannah Rose Brodell, I think you're gonna do the part of the attorney instead of Miss Sloan, or if y'all want to do it together, that's fine. Beatrice Taylor, a friend. Christy Sheremy, Louisiana Parole Project, Stephanie King, a friend, and Demetri C. Moore, Louisiana Parole Project. In opposition, we have Tanya Gaspard, victim sister-in-law, Paula Beret, I'm sorry if I pronounced that wrong, victim's friend, Guy Dessel, victim's family, Isaac Guillory, victim's family, Mandy Guillory, victim's daughter, and Patricia Bush, victim's friend. I will call on y'all also at the proper time to make your statements. Also, Warden, what do you have to tell us about Ms. Roberts?
Good morning. Sharon is one of our minimum custody inmates. Like she had mentioned, she has gone back and, finished up her schooling. And I think that was quite a success for her, which we are very proud of her for that. She works as a healthcare orderly. And like Mr. Hunley even said, she has not had, a write-up in over a decade, so no disciplinary issues. She really is wonderful about coming to work and pitching in where she needs to. So we really do not have any issues, and we fully support if she's granted today. I know she'll do well at the Parole Project.
Okay. Thank you, Warden. Appreciate that. Okay, Ms. Barton.
Hey, good morning. My name's Audrey Barton. I'm a licensed master social worker with the Louisiana Parole Project. I met with Ms. Roberts on July 2nd to conduct a needs assessment. The social workers evaluate all of our clients, but Ms. Roberts' legal team suggested that she might benefit from some additional one-on-one time. I initially met with Ms. Roberts at LCIW for 2 hours, and then last Friday I spoke with her via Zoom. Both times that I've met with her, she was very cooperative and friendly. Ms. Roberts' legal team informed me that she was in special education during her school years, and based on my conversations with her, I've observed some symptoms consistent with an intellectual disability, which might give us some insight on her ability to effectively express herself. I'm aware of her previous charges, and I've spoken with her about the behaviors related to these acts. Ms. Roberts experienced trauma during her adolescence and early adulthood, but she has engaged in efforts to process and heal from these experiences to the best of her ability and has developed tools to manage her feelings of anger. Ms. Roberts reports on maintaining 23 years of sobriety and appears committed to her continued recovery and personal growth. As an additional step of her reentry plan, I will refer her out to individual therapy. The social work team here has a relationship and referral process with Excel Behavioral Health. Excel has a team of psychiatrists, social workers, and counselors that have committed to provide Ms. Roberts with therapy focused on impulse control and decision making. Ms. Roberts has expressed openness and willingness to work with me and follow all treatment recommendations that I gave her. I'm confident that she has the capacity to comply with any recommendations given to her. And of course, if Ms. Roberts is released, she will have ongoing support from a dedicated social work team committed to walking with her every step of the way. Thank you.
Thank you. Okay, and last we'll hear from her attorneys. I don't know which one wants to speak first.
All right, I think Miss Christy Sheremy wanted to speak as well, if the board will allow, before Miss Grodell speaks.
Who's that now?
Christy Sheremy.
Okay, we didn't have you down to speak, but Ms. Jeremy, would you like to speak?
Yes,
ma'am, go ahead.
I think there was a minor minimal discrepancy on how many people were already speaking. I think that's why it was changed.
Could be, yeah, we're not supposed to have over 3, and you make
Good
one, but go
morning,
ahead.
Board, and I appreciate this opportunity. My name is Christy Sherry, and I'm the reentry manager at the Louisiana Parole Project. I'm here today not only in that position, but as someone who has personally known Sharon for over 3 years. Sharon and I spent 16 years together in prison. I've been home a little over 6 years, and throughout all of that time, I've known Sharon to be consistent, respectful, and generous. Even when she had very little, she was always willing to give. Whether it was her time, a kind word, or support to others around. She has always carried herself with humility. She stayed focused, avoided trouble, and surrounded herself with positive influences. Most importantly, Sharon has taken full responsibility of her past. She doesn't talk about it often, but it is clear that she carries deep remorse for her actions. And that remorse has led to her growth. Now at 60 years old, Sharon is committed to her sobriety, grounded in who she is, and is prepared for a new chapter. If granted parole, she will enter Louisiana Parole Project's reentry program immediately. She'll have stable housing, a support system, and a structure needed to help her to succeed. I'm also going to be her case manager, and I'll be here to help her adjust and move forward day by day. Starting over after decades is not easy. I know that from experience. But I also know when someone is ready. And Sharon definitely is. She's done the work, and she has people who believe in her. And if granted, we await her release. I believe in second chances when they're earned. And Sharon has done just that. She is ready to live a quiet and stable life, one built on accountability and community support. And I just want to say thank you all for your time and consideration in this matter.
Thank you. Okay, and now we'll hear from her attorney.
Thank you. To the honorable members of this committee, my name is Hannah Rose Grodell. I'm an attorney with the Louisiana Parole Project, appearing before you today to request the parole for Ms. Sharon Roberts, who at 60 years old has served more than 75% of her sentence. Sharon Roberts has transformed and today seeks not just release, but the opportunity to rejoin society under structured supervision and with the full backing of a deeply invested support network. Ms. Roberts has difficulty speaking openly about her past, not because she doesn't take accountability, but because the pain of what she did is still very present. It is painful for her to talk about causing the death of someone she loved. Her struggle to communicate stems from the deep shame she carries, the grief she feels for the Gaspard family, and the toll her actions have taken on her own life. But those of us who know Ms. Roberts, her legal team, our social workers, and the women she lived alongside for decades have seen firsthand the depth of her remorse. So while you may not hear it in the same way you do in other cases, you can see it, and she feels it. Ms. Roberts was placed in special education as a child and still recalls being labeled a slow learner. She has always struggled to understand and express things the way others do, and over the years, trauma and poverty compounded those challenges, leaving her vulnerable and without many tools to advocate for herself. Yet despite those obstacles and the tremendous pain she has carried, Ms. Roberts was determined to change and has spent the last 23 years doing just that. Ms. Roberts' record demonstrates discipline, growth, and perseverance. As you've heard, in 2019, she earned her GED, a milestone that took time, effort, and determination. She held the same maintenance job for 18 years, demonstrating reliability and responsibility. She has completed every rehabilitative program available to her. She is 23 years sober and has worked tirelessly to maintain that sobriety through ongoing substance abuse programming and weekly AA meetings. She has learned to manage her emotions. She's not received a disciplinary infraction for over 13 years. She's liked and well respected within LCIW, earning herself a level 3 trustee status. And perhaps most importantly, she has formed strong and supportive relationships, creating for the first time in her life a sense of trust, safety, and belonging. The letters of support submitted on Ms. Roberts' behalf describe her as one of the most selfless people others have known. This is the Sharon Roberts before you today, a woman who is loved, changed, and now devotes her spare time to volunteering with her elderly peers. We are not here to suggest that Ms. Roberts' past should be forgotten, nor do we believe it ever could be. Rather, we ask that you consider her present and her future. She has proven she's not a danger to the community. She is committed to continuing her recovery. She understands she used to use alcohol to numb her pain and gave in to impulsive reactions, but today she relies on healthy coping skills. Ms. Roberts is also eager to work, something she takes great pride in. She's surrounded by a strong network of supporters who will continue to hold her accountable, care for her well-being, and want to see her succeed. Releasing Ms. Roberts on parole rather than through good time will allow us to ensure she receives the full scope of our services. We've created a detailed reentry plan tailored to meet her particular needs, including access to licensed counselors, a personalized sobriety plan, job placement assistance, and monitored stable housing under the care of Christy Jeremy, who knows and understands Ms. Roberts well. Having intellectual deficits, living through trauma, and struggling with alcoholism does not make someone dangerous. It means they need support. And Ms. Roberts now has that support, and she's shown she's ready to use it. At 60 years old, with over 2 decades of demonstrated growth, accountability, and rehabilitation, this moment represents not just an opportunity, but the right time for Ms. Roberts' release. Today, Sharon Roberts comes before you not as the person she once was, but as a woman who is humble, changed, and ready to live her days in peace, sobriety, and service to others. So for these reasons, we respectfully request that you grant her parole, and thank you very much for your time.
Okay, thank you. Okay, now we're gonna go to those in opposition, and y'all can speak in whichever order y'all want to go to, so y'all choose who wants to go in.
This is my mother. The person who's not here today because of her. Happy, healthy, full of life. I'm here today to speak on behalf of her because she was tragically, brutally murdered 2 days before her 44th birthday. September 14, 2002 was the worst night of my life. Sharon Roberts, my mother's killer, set my mother's trailer on fire, knowing she was inside. That monster entered the bedroom, seeing my mama sleeping in bed, and deliberately went in the living room and ignited a fire where she had no way to get out of there. She was trapped. She wanted to make sure she was in there and she would die. After I was informed that had to identify her body, I felt an overwhelming sense of emptiness because part of me died that night. The loss of my mother has been devastating. It has been incredibly difficult. The pain is unbearable. It has led me to commit suicide, and I almost attempted, but God's keeping me for some reason. I have to take medication every day to cope. Since I've learned that she wants to get on parole, I've been sick, mentally and physically sick. I can't eat or sleep or do anything else. I shouldn't be going through this right now because the sole reason of agreeing for her to plead Oregon to manslaughter was that she would have no parole. So this was a bomb dropped on me a couple months ago. So I started digging and digging and digging, and the things I have found would make your skin crawl. She doesn't need to be in society. She's in danger. She's great in jail because she's confined. She doesn't know how to live outside. She's been in and out of jail her complete life. The time that she was out of jail, She committed a crime to go right back to jail. Arson. And it was all places that had dwellings that were occupied. She could have killed over 30 people that I myself have calculated. They should have, they have a 3-strike rule. I don't know what happened to that. She has 5 felons. 5. She should have life in prison. The biggest regret I have right now is that I didn't go to trial and fight for the death penalty, because this was premeditated. She went in several times. There's BS about her alcoholism. How are you gonna be an alcoholic when you're in jail all your life? Honestly. October 1st, 2002, she was scheduled to be back in reincarcerated. But she was 3 months late on her probation fees. She couldn't afford probation. How she's gonna afford vodka or whatever else she's got going on? That's a lie. She's not an alcoholic. She's trying to use that. The same time, October 1st, my mama was moving in apartments for disabled people that felons were not invited to. My mama wanted her out of her house. My mama was scared. I have statements from many people of Falls Parish that she would tell that she was scared of her life from Sharon and wanted her out. There's no remorse. This, I don't even know what that was today, but okay. My mother was so burnt. Her hands were burnt to the bones. She got out of the bed. She knew when you have fire, 40% is fatal. She had 86%. She fought for her life. She knew what was going on until she took her last breath. I've had so much pain and suffering. My kids have felt it. I've never had a real life after that. Never. I have nightmares. I want my mama all the time. I wanted her here. I called for my mama here. I'm 49 years old. She died at 43. When I was 43, I wanted to die because it wasn't fair that I was alive and she loved her. And I want to end and ask you, do you think that this repeated violent felony offender should live in the free world? She's too dangerous. She's just too dangerous. Her history proves it. She does not need to be out of jail. And as soon as she does, she's going to repeat this and kill another innocent soul. You can't go from doing something all your life to just shutting it out. And the only reason why she hasn't done it in the last 23 years is because she's been fined. And that's what I want to tell you. And this, I want to let you know, is the last Christmas with my kids. This is my son. This is him whenever he lost his grandmother. This was my daughter. I had to tell her for her birthday, your grandma's dead. This is my mama's birthday, my daughter's birthday, and my mama's birthday is right after each other. And this is the second time she tried to kill my mama on her birthday. And I do have a picture, I don't know if y'all can see it or bear it, of my mama burned. How bad it is. I don't know if y'all want to see it, but it's bad.
We got a lot of stuff in the record.
It's horrific.
Yes, ma'am.
And she knew about it this whole time, and she could have gone back and saved my mama's life, but she didn't.
All right, thank
An
you.
animal. An animal. This is my son.
Okay, okay, and state your name and if you want to tell us.
Isaac Hillary,
Yes, sir. Okay, go ahead.
son of the victim, Amy Gaspar with my grandmother. Unfortunately, I was only 2 years old whenever my grandmother was taken. Not only is Sharon Roberts murderer, she's also a thief. She robbed me of my grandmother. I didn't get a chance to say and know her. I don't even know what she sounds like. The only reason why I know what she looks like is because of pictures. No videos. She robbed me. I never had an opportunity to know, oh, was she the grandmother that would fatten me up give me money, or she was strict, mean, I would never know. And given the fact of her past, of Miss Sharon, like my mother said, there's no way with someone with that, again and again and again, multiple accounts of arson, and possibly could have killed other people, that should not be on the streets. And I agree with my mother, there's no way that she shouldn't just get 30 years, she should get the death penalty, in my opinion. Is it gonna work? Will my opinion matters to that? No, of course not. But the fact of the matter is, someone like that does not belong on the streets. That is just a hard, she's gonna hurt someone. It might not be the next day, might not be within the first week, but I can tell you within at least a month, someone's gonna get hurt because of her going out on the streets. And to say that childhood trauma has to do with the way that she acts, I call BS. My father is an alcoholic, abusive drunk. He's been abused me, my sister, and my mother. Did I go kill someone? No. Do I do drugs? No. That's an excuse, and it's not worthy of an excuse. That's not fair. You can't say, oh, I was abused as a child, let me go kill somebody. That's no excuse. Thank you.
Thank you. Okay, and Ms. Patricia Bush.
Okay, my name is Patricia Bush, and I'm a friend of Amy Alteen Gaspard. She had an inner beauty that is unforgettable. She was a trusting friend, and most importantly, a loving mother. Mandy Gilbert and a grandson, Amanda and Ice. When she spoke of her daughter, she had a ray of sunshine. She had so much life and so much love to give. And on September 14, 2002, Sharon Roberts said to her, took Martine's home and took the life of Amy Martine Gaspard as she slept. Amy Martine lived with him and was unable to escape. That day, she not only took Martine's life, but the quality of life for her only child, her grandchildren, her brother, father, and siblings. The loss of Mandy's mother, which was also her best friend, is forever altered. The grief, fear, anxiety, depression, and all the tears that Mandy and her family has endured will continue, for nothing could ever fill that void in their lives. Excuse me. It's been 23 years, Mandy visits her mom at the graveside. And many days, a week, she's there. Sharon Roberts also set fire to my parents' home. I've seen with my mother, stepfather, brother, sister, nephew, been through and Sharon Roberts set fire to their home. February 19th, 1990. And this was shortly after she had gotten out of jail. That she had supposedly was to serve 5 years, and she may have been out 3 months when she set this fire. It wasn't an accident, she purposely said. She knew they were sleeping, and she set that fire that day. My mother was at the hospital with my stepfather that had to undergo surgery, knee surgery. And thank God in heaven, my nephew woke up. And when he woke up, we went to get water. We opened the door to the kitchen and living area. It was an older house, it had a very long. And he yelled because it burnt his hand. My brother jumped up and he went to the door. And when he pushed the door, the home went into flames. My family, my brother, my sister, and my nephew got out with him without any form of injury. But the emotional trauma remains. That's something that you can't get over. My parents worked very hard for what they had. They were seniors. You can never recover everything that you lost. I had to go to the hospital that day to let my mother know that the house had been burnt down. Everything was gone. My brother, sister, and my nephew's wife. Took them home. They came to stay with my house. I was able to house. And my mother came back home, and my stepfather, they came to my house. My mother cried uncontrollably. Everything that they worked for and all their security was forever over. They had to close on their back with no answers as to what had to come. I seen the tears, anxiety, depression, and emotional stress as I went with myself to see my family and my mother suffer in her senior years. Each time Sharon Roberts committed arson, it was planned. It was never. She knew what she was doing. She knew people were in the homes as she set the fire. She had left that home that day, knowing she couldn't stay there because my parents were coming home. And she left that day. But when she left, she made sure that no one was going to stay at home. She succeeded. There's a history of arson and has disrupted and destroyed so many lives, hopes, and dreams. I plead with the Lord that she not be granted parole. She is a continued threat to society. She, at the time we didn't know Sharon had committed this crime. And she actually showed up at my home. And I told her I had to go to work. And when I went to work, I came home early to check on my parents to see how everything was going. And she walked up to me with a glass of cola with ice. And as she gave it to me, I went ahead and I drank it. I became so ill. I went to my bed. When I got out of bed, I was crawling. My mother made me weigh 100 pounds. She was a very small person. My brother, my stepfather had just had me surgery. My brother had to pick me up, and I had to bathe the sick and have him care. Later, she asked me to go. Oh, she told my brother she put something to drink. I just say that she doesn't deserve to be in the streets. And I hear what they say. But I plead with y'all today, save life. Save someone else. Thank you.
Okay, now we're gonna move on into the interviewing stage. Mr. Byright, you've been assigned the case.
Yeah. Ms. Roberts, how many fires have you lit?
3 of them.
3? And why were you lighting the fires again?
Out of anger.
Anger. That's the only questions I had. I do note that you had 4 periods of probation or parole already, and all 4 of them got revoked, which is not a very good record. And that there's strong opposition from law enforcement. That's all the questions I have.
Just real quickly, Ms. Roberts, you do have a lot of revocations. What's your problem under supervision? Why can't you follow our instructions?
Have no place to go, and I just revoke.
Okay.
I had no support.
Ma'am?
I had no support outside. I mean, out there, and had no place to go.
If you burn it down, where you're supposed to be staying, I mean, it's kind of tough, so. All right, I have no further questions. Panel ready to vote? Yeah, okay, Mr. Barra.
Ms. Roberts, I've read the letters of support, I've read the letters of opposition, I've read the parole projects letters and all of that. You're doing well in jail, and I commend you on that. However, I got to vote to deny this parole request because of the strong law enforcement opposition, the strong victim opposition, your criminal history while on supervision, 4 periods of supervision already revoked. You haven't convinced me that anything would be different.
Ms. Leduc?
My vote today, I just want to know there are 277 pages in one file and 30 in another. And I've read everything. I've listened intently. My vote today is to deny parole based on prior criminal history, prior unsatisfactory supervision. He pled down from 2nd degree to manslaughter, and opposition by all interested stakeholders.
Okay, and you already know the outcome, but my vote would be the same. We're lucky we only have one victim. Very, very lucky we only have one victim. So your parole's been denied today. Good luck to you.
Yes, sir.
I don't know if you guys got to hear denied, but I did not. I'm a little glitchy this morning. I don't know why. So in case you didn't hear it, I'll just do it. Denied. I know I'm not the same. Best I can do. But speaking of Michael, him and Bailey were whining in the chat early on that we needed 9% more Judge Boyd. So here you go. Here's some more Judge Boyd.
Because I had them yesterday. I had the files. It should be visible by.
Hello.
Morning.
Morning. A day without Odyssey. Is it a joy? I don't know. We shall see.
I thought it was just me this morning. I didn't realize it was everybody's.
Oh, no, everybody. And I don't believe there's a backup plan.
Why would we plan for that, right? That goes against everything we stand for.
And whenever I bring up backup plans, because I'm always thinking you should think of worst case scenarios, right? My questions were never answered. Like, what's the backup plan? You're making more room because all the files will be gone. But if Odyssey fails, what's the backup plan? And guess what? There's no backup plan.
There is none.
No. So, Mr. Cavazos, just be patient with us. We're trying to see if there's a physical file.
Yes, ma'am.
There may be a physical file, there may not be. But what are we here for today?
Judge, there were a couple things. One, Mr. Cavazos has filed an amendment to Mr. Rodriguez's bond. It was something, essentially it involves, previously, Mr. Rodriguez was unable to see his child without supervision.
Okay, I remember you all discussing this with me.
Yes, ma'am. And the state did look into it. I did talk to the mother of the child. We have no concerns about amending that condition. I think you would ask Mr. Cavazos to get the CPS order as well as maybe some other
Yes.
paperwork, which I believe he has supplied to. So the order then was given to the court, but I believe you may have been in trial at the time.
Yeah.
So I think we had to reset it till today for you to make a decision on
And does
that.
he have a pretrial services officer or no?
I believe he does, but do you know, does he have? a
Eric, who's the individual that you report to?
I can get you the name on the phone.
Okay, well.
I can need it today.
Yes, who is the person?
I'm gonna get the name, man.
All right.
She's loading.
Technology. is all over. So-
Oh, it is.
How often do you report, Eric? Can you answer that?
Once a month. I have to report today.
All right, thank you.
I mean, yeah, I know.
Officer Mendez, Officer Mendez,
I'm sorry, who?
Officer Mendez.
Let me see. Oh, what's the first name?
It doesn't show, it just says Officer Mendez, pretrial services.
Would it be Celeste Mendez?
Or no.
Let me try. Maybe it's, but it also could be Roman.
Do you have a phone number or an email for them, Eric?
It's a 188 number. I don't think it's gonna work. Call her.
No, it shouldn't be an 8 number.
Or I get a text a reminder every month.
All right, well, do me a favor, text them and tell them that the judge wants to speak to them. All right, we're going to go on the record. Court is calling 2021 CR 0735 State versus Eric Rodriguez. Can I have parties announced for the record?
Stephen Spear for the state.
Jaime Cavazos for Mr. Rodriguez. There is another case also, Judge, on your docket for Mr. Rodriguez.
Yes,
And
I'm sorry. And also 2021 CR 0699.
Correct.
And are you Mr. Eric Rodriguez?
Yes, ma'am.
All right, so we're here for, the first thing we're here for, it's in regards to having contact with your son, is that correct?
Yes, Your Honor.
All right, and your counsel in the state did discuss with the court what the issues were. The court wanted certain items given to the court before I make a decision on whether or not to grant the defense's motion. My understanding is that the state, you're in agreement with the defense's motion?
That is correct. We have no objection to the motion.
So the court wanted proof that the Child Protective Services case was closed, or there was no concern from the worker defense. Our systems are down. You're an officer of the court. Can you tell the court, do you have that information?
Yes, Your Honor. I believe I'd actually forwarded to Your Honor via email. And in addition to that, a statement from the biological mother of the involved child, wherein she expressed to the court that she had no concerns or reservations with Mr. Rodriguez being unsupervised with her child.
All right, and have the visits been supervised prior to this?
Yes, Your Honor, they have.
All right, and how old is the child?
Eric, can you help us with it?
He's 12 right now.
He's 12?
Yes, ma'am.
All right, so I believe and there's some sort of child custody arrangement?
That I'm not 100% sure. That's my understanding, but perhaps defense or Mr. Rodriguez could speak to that.
All right, defense, is there a child custody arrangement?
Mr. Rodriguez, could you answer that question? Is there a court
You want to
court
raise
order?
your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Eric Rodriguez.
All right, is there some sort of custody agreement legal custody agreement between you and the child's mother?
Yes, ma'am. We have joint custody. I get them every other week.
Every other week?
Yes, ma'am.
And can you tell me, was the custody arrangement in place before or after the alleged incident that you're here for?
It was before the incident.
All right, so after the alleged incident, were there changes in the custody agreement?
No, ma'am.
All right, but there was Child Protective Services involved?
Yes, ma'am.
All right. And Child Protective Services, did they have you do some sort of service plan or no?
No, ma'am.
All right. But did they interview you? What did Child Protective Services do?
Yes, ma'am. They interviewed me, my child, my family, and it was closed the next day.
All right.
Your Honor, I believe Child Protective Services made the decision to close the file back in 2021. I don't know the exact date, but it occurred very early on. And there was no motions to modify the court order possession order by the mother because she had no concerns.
All right. Well, I will tell you this, if you all will write an order, the court then will sign the order and grant it. There are no orders attached to your motion for some reason. I believe that's another Odyssey glitch.
Well, Your Honor, I believe we had the order in back offices but I just don't know where the order actually ended up. Because it was before the file actually made it to the court.
They're somewhere in Odyssey.
Oh, okay.
We'll regenerate an order, Judge.
Oh, yes.
With
And I don't need the entire motion, just an order. And if you can send it to me, and you can send it to my email.
Okay.
And well, actually send it to the coordinator's email.
Will do.
I'll put it in the chat. There's no dot in your email, is there? All right. Okay. Now, then the next thing we need to take up is the motion for continuance.
Yes, Your Honor. This case went first to the trial court, obviously, the 226 then, and a motion to suppress was granted. The state appealed that decision to the fourth court, which affirmed. There was 4 issues that were before the fourth court of appeals. And the decision was to affirm the trial court's ruling. The state appealed the fourth court's decision to the Court of Criminal Appeals. And the Court of Criminal Appeals dealt with one issue and one issue only, and specifically said in its ruling that it left the other issues undecided. To be, or basically they didn't deal with them at any way. And for whatever reason, the Court of Criminal Appeals in its order indicated that the file should be sent to the trial court rather than the fourth court of appeals to deal with the remaining issues. Defense counsel that's handling the appeal out of Austin, Mr. Schulman, filed a motion for reconsideration and for clarity as to where the Court of Criminal Appeals is directing the file to be sent to. And there's been no decision on that motion as of today.
All right. And when was that motion filed with the fourth court? If you know, approximately.
With the fourth court or the decision?
I'm sorry, the Court of Criminal Appeals.
I believe that was. I'm looking it up on my computer, Judge. Give me 1 second.
No problem.
Okay. Looks like May 15th, Judge. The decision was delivered on May 14th of 2025, and I received a copy of that through defense or appellate counsel on May 15th of 2025.
And what is his request from the fourth court, please? For clarification?
No, the motion for reconsideration was filed with the Court of Criminal Appeals.
Oh, so he's filed a motion to
For
reconsider?
Exactly, yes, and for clarification on the directive or the mandate as to where the case is to be sent to for further action.
All right, this is what we're gonna do. Ms. Ferguson, on this case, if you can give them a 60-day reset. And I won't, even though our work is being graded on how we move cases, I'm not gonna charge either you with a continuance use, because I know that one, your client does need clarification. And if there's a request from clarification from the higher courts, then that needs to be done before this case really moves on. So 60-day reset, please. All right, so we'll be back on September 11th. And while this case is working its way through the system, if you all can make sure that all discovery is completed.
Of course.
All right,
Yes,
is there anything else, counsel?
No, Your Honor, I'll work on that order and send it to Mr. Spear for review and signature that he's agreeable with the language, and we'll forward it to your clerk.
All right, thank you.
Thank you.
You can put it as a discovery.
Are we
All right,
excused, Judge?
you're excused. Once you sign the reset form, you will be excused. Thank you for dressing appropriately for court.
Yes, ma'am. Thank you.
Thank you. Thank you, Mr. Cavazos.
Thank you, ma'am.
Thank you for hearing us. sir. Yes, sir.
Well, that was a fairly long hearing, so that should help with that additional 9% Boyd you guys are looking for. Let's head east to west.
Good morning. All right, this is cause number 1830854, and sir, you're Juan Sanchez? And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So, but we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results, testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the.
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that. I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff, so.
Sure.
I kind of agree with
So-
you. I don't know that subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May. I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay,
And
I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes, Your
so
Honor.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today
Yeah.
to turn over.
I mean,
Unless
yeah.
there was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, or do you have any concerns you want to
If there's,
make the court aware of?
Your Honor, just with the clarification of, our departmental chronologicals, which include, anything that pertains to the case that happens, we chrono telephone calls, auto-generated, appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed, with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out, though, I think whatever Mr. Nichols, y'all get together, Obviously, offense report, if y'all have the offense report and you don't even have it, then you need to get, I mean,
Right,
that's,
I mean,
that's great.
it's
Everybody
all
can
stuff-
get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real,
that's what I'm thinking about, but it's
Not
not
so
really
concerned.
attorney's notes, and so I don't know that that would
I
be an
would object
issue.
to that, Your Honor, on the grounds that it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
And that's what I just said. You seem very frustrated, and I'm not sure why. I mean, I don't know,
I'm confused why there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And
Your
the
Honor.
last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here, or sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial, of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in what, a couple weeks or so? Fine with that?
yeah, that should be fine, Judge. We'll be able to
Okay.
get everything scanned in and provided through the portal.
Perfect, thank you. All right, y'all are all excused.
Be needed?
I'm sorry? No, ma'am, if you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're gonna have to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations, then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay? Good?
Yes, Your Honor.
All right, thank you, y'all.
Thank you.
So Barbara, thank you for gifting that membership, and Ashley, thank you for gifting 5 more. You guys continue to be kind, not only to me, but to the community, and it's always appreciated very, very much. I'm going to leave you guys with Judge West. I need to step out of the studio for just a few minutes, but I will be back. But in the meantime, like I said, we'll leave you with Judge West, and Ashley, I'll leave you in charge. I'll be right back.
Good morning. Thank you for coming real quick. We'll at least take care of Mr. Miller so they can get him. Okay. Mr. Coleman, we're gonna take care of Mr. Miller. It's a competency. All right, this is cause number 241916, and are you Edward Miller? Good morning. And so Mr. Miller was evaluated by Dr. Hamza for competency to stand trial. I received that report dated June 26th of 2025. The finding in that report is that Mr. Miller is not competent to stand trial. Is there any other evidence with regard to competency? Ms. Holmes?
No, Judge.
And then at this time, I am going to find that Mr. Miller is not competent to stand trial, that inpatient treatment is required for competency restoration. Order you to the appropriate facility. This is just to get you some help, Mr. Miller, okay? And we're going to get you some help, and then we're going to get you back in here. And it'll be for a period of not to exceed 120 days from the date that he gets to the appropriate facility. All right, you can go back with the bailiff.
I just want to remind you, we added that on the guy from yesterday with the flight, Charlie.
Oh,
It's not on the docket anywhere, that's why.
and what was it set for?
It's just.
An announcement?
Yeah.
What? Oh, okay. But is it on the, is it gonna show up here?
You may have to refresh your calendar, but it's yes.
Okay, all right.
Judge, if I could choose.
If, it goes,
Does it still need to be a case pending for him to remain committed?
yes. So the only other option would be to go through the civil, go through a civil commitment would be an option. And so if you get that done, the case can get dismissed, and then he can go a different route, but you have to get with your people on how to do that. I know Ms. Malfino's done it on some, but it,
I don't want to mess with his ability to get treated.
I mean, if it's, obviously there's some issues that need to be taken care of, so perhaps we get the initial competency restoration done and then do it at that time.
I'll make a note on file.
Yeah. Yeah, how did that feel coming? Oh my gosh, I've got so mad that I'm shaking still. Like, I haven't been that frustrated in a long time. Mr. Kimler, you have Reagan Howard. I just don't do well with that stance.
Mr. Smith and I are getting along now.
Thank y'all very much. Appreciate that.
It's not a bit of old friends.
That's an interesting way to start the morning.
I just been going through the motion. If somebody to or not to, then I'll ask her mom. And she did have an email letters.
Good morning, ma'am. You're Reagan Howard.
Yes, ma'am.
Ms. Howard, would you please raise your right hand? Best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. Let me get this. And she's just going to plead to the motion.
Yes, ma'am. Yes, Your Honor, and I get it updated to the side, and Mr. Smith, there may be evidence he wants to put on it here.
Okay. All right, let me get this pulled up. Ms. Howard, in cause number 2239924, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2024 for the third-degree felony offense of deadly conduct discharging a firearm, and that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department October 7th and November 1st of 2024. And is that true or not true? The dates were October 7th and November 1st of last year, 2024, that you did not report. Is that true? Okay. Count 2 alleges that you're behind in your court-assessed fees, and is that true or not true? Count 3 alleges that you also failed to report June 27th, August 21st, and September 24th of 2024 to the probation department. Is that true or not true?
That's true.
Count 4 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
That's true.
Count 5 alleges that you failed to immediately report your contact information as ordered to the probation department. Is that true or not true?
That's true.
Count 6 alleges you provided a urine sample August 27th of 2024 that tested positive for alcohol. Is that true or not true?
True.
Count 7.
Tied to the same UAPH.
So count 7 alleges that on that same date of August 27th of 2024, you also tested positive for cocaine. Is that true or not true?
That's true.
And then count 8 alleges on that same date, you also tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 9 alleges that you did not provide verification of performing the community services required. Is that true or not true?
True.
Count 10 alleges that you did not provide verification of entering and successfully completing the anger management program. Is that true or not true?
Not
Not true. I didn't get assigned to anger management.
Okay. Count 11 says that you did not submit to alcohol or drug screening September 9th and September 16th as and then apparently you had possessed a device or an object for the purposes of providing a fake specimen. Is that true or not true?
Not true.
Count 12 alleges, again, that you're behind in your court-assessed fees. This was done a little bit later, so the amount is more. Is that true or not true?
True.
And then count 13 alleges that you didn't provide verification of entering and successfully completing the moral recognition therapy, the MRT program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 9 and then 12 and 13 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to those counts freely and voluntarily, find them true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing. We'll get an updated pre-sentence report done. And if at that time the state wishes to put any evidence on with regard to counts 10 and 11, they can do so. And then anything that you think is important for me to know at that time, get that information to Mr. Kemmler. He'll present it to me on your behalf when we come back. And this is unagreed.
Correct,
Jody.
Your Honor, there's something.
Okay, all right.
Your Honor, we had asked for a bond. I think if the court would set a reasonable bond for Ms. Howard, and she were able to post that bond, she would be able to demonstrate to the court.
That's denied. I'm going to find at this time it is in the best interest of our community and under the Article 1517 that even though this is a deferred probation, based on the nature of the underlying offense, which is a deadly conduct discharging a firearm, the fact that it looks like Ms. Howard has done pretty much nothing, including not reporting while she's on probation, and when she did test positive, that it is not safe at this point until I have more information for her to be out. So that's denied.
You did have her support letter.
Yes, and I've already received those, and we'll get those to probation as well so that they can be part of that pre-sentence report. Okay, you can go back with the, what's that?
So is ISF off the table?
Well, I don't know right now until we come back for sentencing. So probation will come talk to you, talk to Mr. Kemmler. I'll get all the information about what's been going on, and then I'll make a decision when you come back about whether I keep you on probation, revoke your probation, keep you on probation, send you somewhere for treatment. It just depends on the information I get when we come back, okay?
And I'll be out to see.
Okay, you can go back with the bailiff.
Okie dokie, folks. I want to go back to Louisiana and try another hearing, but We're going to do some real-time checking on the fix. So I'm going to play the approved and denied audio just to see if it's working, because I'm trying something here. So let's try denied. And it's not working, so let me figure out why. If I can. What gives? Hi, Ellie. Whoop, don't fall, sweetheart. This is riveting programming here at the Courtroom Files as we, in real time, try to figure out why stuff doesn't want to work. And I just don't have the answer. Huh. Well, guys, we're going to go to Louisiana anyways, but I don't know why the Stingers don't want to play today. So apologies, Michael. You put in all that work for the channel, and for whatever reason, I can't get OBS to cooperate with that today. But, you know, what are you going to do, I guess? But let's go ahead and roll this hearing, and we'll see what happens.
We'll call the parole board back to order. Time is 9:58. My name is Pete Freeman. I am the acting chair today. To my right is Mr. Barra. To my left is Ms. Ledoux. We are now at David Wade Correctional to hear the case of Jacob Griffith for parole. We'll put some stuff in the record, Mr. Griffith. You are a first felony offender. You do not have a good time date. You have a full term date of 8/14/27. Your total sentence was 23 years. Your charge was forceful rape. Does that sound correct?
Yes, sir.
Okay, would you please state your name and DOC number for the record?
Jacob Griffith, DOC 503310.
Okay, would the staff at the prison please introduce yourself?
Deputy Warden Brenda Ackland. Thank you, Trippiano, ARDC Manager.
Danny Henshaw, classification.
Elizabeth Savage, Lieutenant Colonel.
Okay, thank y'all for hosting us today. We appreciate it. Okay, sir, would you tell us your name? Not tell us why you're in prison and why do you think we should consider letting you out today?
I'm in prison on forcible rape charge I committed in 2004. The reason why I believe I should be granted parole is when I came to prison, I was a child and I made some bad mistakes. And through these 21 years that I've been locked up, I've gone through my classes, I've gone through my risk management, and I've been taught, you know, how to not put myself in a predicament or in a high risk area. And that's pretty much it.
Okay. All right. Today we have speaking on your behalf, Ms. Griffith Santos or Santos Griffith. Ms. Griffith. Probably on mute, ma'am.
Okay.
Okay,
Yes.
go ahead. Tell us what you want us to know.
My name is Santos Griffith, and my son is Jacob Griffith. And I just want to say that I'm losing two of my best friends. My husband is in the hospital right now, and I need Jacob home where he can help me. He's been gone so long. And I just can't do it by myself. We're both 76 years old. And right now, my husband's fighting for his life upstairs. I'm at the hospital right now, and I had to postpone to come to this meeting, leave him by himself. I know my son's, what he did when he was younger. I know he made mistakes. There's been some times that it's hard for it to go on Knowing that your son's in jail and your husband's bedridden in the hospital and not expected to live much longer. I need him to at least be able to say goodbye to his dad, or to come help me with him with whatever time the Lord provides.
Thank you, ma'am. I know you're going through some difficult times.
Thank you.
Okay, next we'll hear from Rachel, Gross in opposition. Mother? Go ahead, Ms. Gross.
Hello. I'm here to speak on Cain's behalf, but I forgive Jacob. And I request that you grant him parole.
That is very big of you. Thank you, ma'am. We appreciate it. All right. I was assigned the case, Jacob. What did you go through sex offender treatment?
Yes, sir.
Okay.
All 4 phases.
And did you do the instructor part also, or you just did the first 3 phases? Did you teach
First
class?
4 phases.
Okay. And what did you get out of that?
It taught me about like the Rocco scale, where am I at? You know, if I'm a level 1 or 2, I'm in a safe place. If I'm 3 or 4 or 5, I'm in an area where I need to be cautious, and anything above that I need to get, for lack of a better word. It taught me about learning myself and learning what my risk factors are, what my triggers are, things of that nature.
I see you have 46 write-ups. When was your last write-up?
I don't know.
July the 9th of 21.
July the 9th of 2021.
It's a low court, 24.
A low court.
All right. And Warden, did y'all have anything y'all would like to say about Mr. Griffin?
Yes, Mr. Griffin's been here at Wade since March the 19th of 18. Like we just said, his last write-up was July the 9th of 21. He has a good overall work performance and a low Tiger score. And since he's been here at Wade, he really has not been any problem at all.
Okay, thank you, ma'am. I have no further questions. Is any of my panel have questions? Panel ready to vote? Okay. What's that? Okay, I'll vote first since I had your case. I'm gonna tell you, you better thank your victim in this case. Her lack of opposition is makes a big difference in our decision. And you've been in there, you have been in 21 out of 23 years, which is a lot. And I do think you need supervision when you get out. And I like for sex offenders to be on supervision for a while. Warden, is he taking his pre-release programming?
Reentry, yes. He took it back in March to May of 23.
Okay, because we didn't have pre-release on our form. That's why we worked.
He has also put in an interstate compact if made parole to Atlanta, Texas, to your aunt out there.
No, my land.
It's his family land out there.
Okay, and has it been accepted?
Not yet.
Okay, so you got a place to stay in Louisiana till that's accepted.
No,
sir.
Not in Louisiana. Not in Louisiana, no, sir.
Okay, well, we have to wait till we get the compact
But
back.
we could, if he granted parole, I mean, the classification can work and find him a place to live.
Okay, well,
until that comes through.
Yes, ma'am. Well, my vote is to grant upon approval for an approved residence plan, follow all sex offender contracts. Mr. Byron?
I'm gonna go ahead and vote with Mr. Freeman to grant parole, but put a special condition, not be around any juveniles, period.
Sir,
Ms. Ledoux?
I'm gonna vote to grant. I do want to point out that, you are a tier 3 sex offender, which means lifetime registration.
yes, ma'am.
I read that you are, receiving some psychiatric treatment and on medication, and that must
Yes, ma'am.
continue on your release. My vote is to
Yeah, that just must continue when once released.
Yes, ma'am.
My vote will be to grant, because you need to be supervised prior to full-time, release. I believe you need some supervision. And so, until he has a residence plan, he needs to be where he is. Great. Okay, thank you.
Okay, today we have voted to grant upon that approved residence plan. And, good luck to you, sir.
Thank you.
Thank you.
Denied. Approved? Again, I'm not Michael Groff, and unfortunately, OBS is not cooperating with me today, and it will not play those stingers. But it would have sounded better from him. I love to promote him. So right there in the chat, go subscribe to Michael Groff if you're not already subscribed to him. He's a good friend of the show. He does sounds and stuff for us, which I can't seem to make work today. But yeah, one denial, one approval. That means I'm probably going to have to show one of these things later to break the tie. In the meantime, let's go back to Judge Boyd.
Judge, so I previously came before this court and erroneously said that discovery was complete, and conferring with Mr. Arglios and reviewing the case myself. This case was done in conjunction with some federal officers, and it looks like some of the federal discovery is missing, and so I need to draft a TUI letter to obtain that evidence.
All right, and how much time do you need?
Judge, I would request 30 days.
All right. All right, I need a 30-day reset on Anthony Herrera, please. No, you need to know what your day is. Do you want to know? Maybe you don't want to know.
I think it's like August 19th.
All right, it's August 19th. Just have a seat and they'll give you a reset form and then you're excused. Thank you for dressing appropriately for court. You're welcome.
Thursday over the afternoon, so I can hold on to it.
Go back and after.
Yes.
That's no problem.
Is he in jail?
No.
Is he here?
No.
They have to be. No. Yes. Or have a good. You let me think that's been.
All right, the silence out of Boyd is riveting for sure, but let's go to Judge West.
All right, this is cause number 241916, and are you Edward Miller? Good morning. And so Mr. Miller was evaluated by Dr. Hamza for competency to stand trial. I received that report dated June 26th of 2025. The finding in that report is that Mr. Miller is not competent to stand trial. Is there any other evidence with regard to competency? Ms. Holmes?
No, Judge.
And then at this time, I am going to find that Mr. Miller is not competent to stand trial, that inpatient treatment is required for competency restoration. Order you to the appropriate facility. This is just to get you some help, Mr. Miller, okay? And we're going to get you some help, and then we're going to get you back in here. And it'll be for a period of not to exceed 120 days from the date that he gets to the appropriate facility. All right, you can go back with the bailiff.
I just want to remind you, we added that on the guy from yesterday with the flight, Charlie.
Oh,
It's not on the docket anywhere, that's why.
and what was it set for?
It's just.
An announcement?
Yeah.
What? Oh, okay. But is it on the, is it gonna show
Yes,
up
ma'am.
here?
You may have to refresh your calendar, but it's, yes.
Okay, all right.
If I just use.
If, it goes,
Does it still need to be a case pending for him to remain committed?
yes. So the only other option would be to go through the civil, go through a civil commitment would be an option. And so if you get that done, the case can get dismissed and then he can go a different route, but you have to get with your people on how to do that. I know Ms. Malfina's done it on some, but it,
We'll just start with, I don't want to mess with his ability to get treated.
if it's, obviously there's some issues that need to be taken care of. So perhaps we get the initial competency restoration done and then do it at that time.
I'll make a note on file.
Yeah. Yeah, how did that feel coming out?
You reach down deep.
Oh my gosh, I got so mad that I'm shaking still. Like, I haven't been that frustrated in a long time. Mr. Kimler, you have Reagan Howard. I just don't do well with that stance.
Mr. Smith and I are getting along now.
Thank y'all very much. Appreciate that.
It's not a bit of old friends.
That's an interesting way to start the morning.
I just been going through the motion. If she'll put it to or not to, then I'll ask her mom. And she did have an email letters.
Good morning, ma'am. You're Reagan Howard.
Yes, ma'am.
Ms. Howard, would you please raise your right hand? Best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. Let me get this. And she's just going to plead to the motion.
Yes, ma'am. Yes, Your Honor, and I get it updated to the side, and Mr. Smith, there may be evidence he wants to put on right here.
Okay. All right, let me get this pulled up. Ms. Howard, in cause number 2239924, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2024 for the third-degree felony offense of deadly conduct discharging a firearm, and that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department October 7th and November 1st of 2024. And is that true or not true?
Can you repeat that? I'm sorry.
The dates were October 7th and November 1st of last year, 2024, that you did not report. Is that true?
That's true.
Okay. Count 2 alleges that you're behind in your court-assessed fees. And is that true or not true? Count 3 alleges that you also failed to report June 27th, August 21st, and September 24th of 2024 to the probation department. Is that true or not true?
That's true.
Count 4 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
That's true.
Count 5 alleges that you failed to immediately report your contact information as ordered to the probation department. Is that true or not true?
That's true.
Count 6 alleges you provided a urine sample August 27th of 2024 that tested positive for alcohol. Is that true or not true?
True.
Count Seven.
Tied to the same UAPH.
So count 7 alleges that on that same date of August 27th of 2024, you also tested positive for cocaine. Is that true or not true?
That's true.
And then count 8 alleges on that same date, you also tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 9 alleges that you did not provide verification of performing the community services required. Is that true or not true?
True.
Count 10 alleges that you did not provide verification of entering and successfully completing the anger management program. Is that true or not true?
Not true. I didn't get assigned to anger management.
Okay. Count 11 says that you did not submit to alcohol or drug screening September 9th and September 16th as and then apparently you had possessed a device or an object for the purposes of providing a fake specimen. Is that true or not true?
Not true.
Count 12 alleges, again, that you're behind in your court assessed fees. This is was done a little bit later, so the amount is more. Is that true or not true?
True.
And then count 13 alleges that you didn't provide verification of entering and successfully completing the moral recognition therapy, the MRT program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 9 and then 12 and 13 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to those counts freely and voluntarily, find them true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing. We'll get an updated pre-sentence report done, and if at that time the state wishes to put any evidence on with regard to counts 10 and 11, they can do so. And then anything that you think is important for me to know at that time, get that information to Mr. Kemmler. He'll present it to me on your behalf when we come back. And this is unagreed.
Correct,
Jody.
Your Honor, there's nothing.
Okay, all right.
Your Honor, we had asked for a bond. I think if the court would set a reasonable bond for Ms. Howard, and she were able to post that bond, she would be able to demonstrate to the court.
That's denied. I'm going to find at this time it is in the best interest of our community and under the Article 1517 that even though this is a deferred probation, based on the nature of the underlying offense, which is a deadly conduct discharging a firearm, the fact that it looks like Ms. Howard has done pretty much nothing, including not reporting while she's on probation, and when she did test positive, that it is not safe at this point until I have more information for her to be out. So that's denied.
You do have her support, right?
Yes, and I've already received those, and we'll get those to probation as well so that they can be a part of that pre-sentence report. Okay, you can go back with the, what's that?
So is ISF off the table?
Well, I don't know right now until we come back for sentencing. So probation will come talk to you, talk to Mr. Kemmler. I'll get all the information about what's been going on, and then I'll make a decision when you come back about whether I keep you on probation, revoke your probation, keep you on probation, send you somewhere for treatment. It just depends on the information I get when we come back, okay?
And I'll be out to see you.
Okay, you can go back with the bailiff.
All right, let's just keep skipping around Texas, and we'll go back to Judge Boyd.
Why are you winking at me? You winked from the side. Here's the thing. Here's the thing. We are not on that level, so don't come at me. Do not come at me on that level. We're not on that level.
Quiet.
All right, you want to take him?
Take him?
Yeah. All right, I don't understand. Why are people winking at me? We're not on that level. All right, Sylvia Noriega? Yes.
This was a motion to adjudicate that was sent a couple of weeks ago.
Mhm.
We set it to see if either restitution had gone to the alleged victim.
Yes.
And that's where we are now. She's been on deferred, I believe, for about 10 years.
So were you able to pay any restitution?
Well, I haven't paid any money yet because I was waiting to see what was gonna happen.
You have a motion to revoke because you haven't paid any restitution. What's going to happen is if you don't pay restitution And it appears, based upon what you've told me, that you have money to pay restitution, but you're trying to see what's gonna happen and hedge your bets. So we can go forward on the motion. Do you want to go forward on the motion to revoke today, council?
No, Judge, I think the issue is she's paid restitution, but we don't know regarding the probation, if all the restitution has gone to the alleged victim or if it's gone to probation. I think that's what the issue was the last time we were in court. to figure it
Right.
out. Unfortunately, today, because the system is down, probation's unable to look at information.
Are you able to come back this afternoon?
What time?
Mm-hmm.
We can have her back at 1:30 and we can see if the systems are up.
Would I be able to do it by Zoom or would you? need
Yes,
it
you can do it by Zoom. Well, you know what, let's not say 1:30 because we have trial that starts at 1:30. I tell you what, we'll recall it for tomorrow and for restitution issues. And if your client wants to appear by Zoom, she can appear by Zoom because it's a matter of restitution. And then if there's an issue, we can always reset it for a contested MTR if that's what needs to be done. All right?
This time, thank you.
All right, so make sure though that you save some money in case they say that you owe restitution, okay?
Yes, ma'am.
All right, do you have any questions about anything? Thank you for dressing appropriately for court and being on time. All right, once you sign the reset form, you're excused.
I couldn't agree with you more, Ashley. She is cuddly and lovey and all sorts of fun. She also keeps me off the keyboard right now. Let's go back to Judge West and we'll keep ping-ponging here.
Good morning. You're Anthony Williams. And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
What's your signature? Mr. Williams, in cause number 240401, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from December 7th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 7 years. There's a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Sorry. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today so they can start that report, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Yes, ma'am. Thank you.
Yes, sir. Mr. Rojas, you have Theron Jackson. Good morning, you're Theron Jackson.
Yes, ma'am. Yes, ma'am.
And Mr. Jackson was previously in court, entered pleas of true to counts 1 through 5 in each of his motion to revoke unadjudicated probations, on probation for aggravated robbery. Actually, 3 cases, an aggravated robbery and then 2 aggravated assaults with deadly weapons, and cause numbers 241324, 1323, and 0883. I've received the updated pre-sentence report. This was unagreed, and has everyone had an opportunity to receive that report and review it?
We have, Your Honor.
Are there any additions or corrections to that report?
Not from us, Your Honor.
All right, Mr. Rojas, you may proceed.
Judge, Mr. Jackson recognizes he's on probation for some serious offenses. And that, you know, in my opinion, it's like he needs help. And main problems come from mental health issues. He's homelessness, he's got lack of transportation, and he's got limited family here in the area. He tells me that when he was first released from jail, he didn't have a place to live, didn't have any transportation. That's the reason for not being able to get to probation department in the beginning. He's been on probation for such a short period of time. He's been unable to get the benefit of the resources that probation has to offer him. I understand all that's because of his not attending probation. But again, I think that all stems from the homelessness and the lack of transportation and the mental health issues. He is trying to get help for himself. He does have the application to get his government benefits. He's got contact with someone from MHMR if he were allowed to stay on probation. He tells me that he has a place to live now. He's going to be living with his cousin who does live here in Beaumont. He is hopeful that he can get his job back at the place he was working for at the barbecue restaurant.
Yeah, that's good.
Hold on.
And of course, that all is going to depend on him actually going to probation. And he tells me now that he does understand that the importance of getting there, he will do everything he can to make sure that he does get to probation if the court were to allow him to stay on probation. And that's what he's asking the court to do this morning, Judge. And at the proper time, I think he does have a statement to make.
Go ahead.
Got a letter. Hello, my name is Theron Jackson. I'm writing this letter pleading for mercy. I started my probation off on the wrong note. Everything I had on probation was in first place. I ended up losing my cell phone and the place that I was living. The people found out that I was on probation and they kicked me out the house. And I didn't have, they kicked me out. I got kicked out the place I was staying at. And the same night, the police had came and arrested me for some unpopular, like some things that I didn't do. And they said I was under intoxication, but I wasn't, you know what I'm saying? Because they was all fighting and stuff like that. And they put me in jail for one night for intoxication, but they didn't have no breathalyzer or nothing saying that I was intoxicated, and they said I was intoxicated, and they was lying. They was lying on me. I don't have, they didn't have any record or proof of intoxication. I got to jail and they released me the next day for public intoxication. I reported the next day, the day that I was supposed to report. You know how they let you out of jail. You know what I'm saying? At like 3 o'clock. It was raining so bad. It was flooding. I didn't have nowhere to get there. So I walked. The next day I waited till it stopped raining, and it was unflooded. And I walked to the probation office, and I told the lady that I didn't have my social security card and my ID, and she said she was going to help me do it. And I was very excited, Judge, for trying to get my GED. I was very excited about going to school, and man, the lady kicked me out of the house while I was staying there, and I had to move in the hotel room, and I ran out of money, and bro, it just all went downhill from there. Yeah. If you can find any way for me to get back on probation, I promise I'm gonna do the right thing, and you know I'm a good citizen, and I help anybody I can. I'm a minister of music. I go to church, Solid Rock, Church of God of Christ, and yeah, man, I've been trying to stay out of trouble. I just been running up on hard times. Yeah, I just need a second chance.
Ms. Malfino?
Judge, I'm not unsympathetic to his situation. I don't think it's something that he's just coming in today saying that he's had these problems. I think they've been ongoing. I think that's why we had initially wanted to give him the opportunity of probation so that he could participate in the mental health caseload. Obviously, he's very lucky to have Ms. Core as his officer, but I have spoken with her several times about this, and she has gone above and beyond just trying to make contact with him to bring him in to say, these are the resources we try to have to help you, and they just can't ever find him. I'm not suggesting that necessarily my position is revocation, but my position would be, Judge, if the court gives him this opportunity, he does not take advantage of it, and he does not do what Ms. Core needs him to do, that the court orders him to do, that my recommendation would be significantly higher than it would be today on revocation based on the underlying law.
You probably haven't even had enough time to know, I guess, my question, Ms. Core, would be, if I continue him on probation, would something like cognitive track of ISF be
Yes, ma'am.
helpful, or that, or either special needs safe P? Which one do you think would be more appropriate to help him get a good start before he gets back out?
I would think very highly of the special needs safety for him.
Okay. Okay. I mean, Mr. Jackson, everybody wants you to be successful,
Yes, ma'am.
but you're the only one that can make that happen. You have all the resources. Ms. Core wants to help you. Probation has all kinds of things to help you, but you have to, they're not going to come, she's not going to come find you.
Yes, ma'am.
So, if I give you this opportunity today, you're going to go get some help in custody. Listen, and when you're out though, and when you're finished with that treatment, it's going to be your responsibility to go where you're supposed to go, to let her know where you're living, and she's not going to go try to find you. You don't show up, then you're going to be back in here, and we will not be having these conversations. Today, I could send you to prison for the rest of your life for violating your probation. Right now, today, for life, for 50 years, for 30 years, for 20 years. An aggravated robbery and 2 aggravated assaults with deadly weapons. You should probably be going to prison. So you need to understand that this is it. There's no second chance. This is your chance. All right. So I'm going to find that you entered your pleas of true to counts 1 through 5 in all 3 cases freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probations and find you guilty, but I'm not going to do that. I'm going to continue your probations in each of your cases. I'm going to order in each of your cases that you enter and successfully complete the special needs track of SafeP. That's going to give you all kinds of help to make sure when you get out, you're ready to go and you'll be making better decisions. You won't have any issues, hopefully, with regard to any type of drug or alcohol abuse, and you will also have aftercare, a place to live, and things like that. So you're going to have what you need, and it's going to be up to you. All right. Good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Core.
So, let's go to Louisiana and try to break the tie.
Correctional Center. My name is Pete Freeman. I am going to be acting chair today. To my left is Mr. Ledoux. To my right is Mr. Barra. We are here now to hear the hearing on Robert Owen. Mr. Owen, state your name and DOC number for the record.
Owen Robertson, 107635.
Okay. Mr. Owen, we're here today for your parole hearing. I'm gonna read some information to put in the record. Mr. Owen is a fourth felony offender. He had a parole date of 6/13/23, a good time date of 6/13/42, and a full term date of 6/8/43. He is serving a 40-year sentence for the charge of manslaughter. Does that sound correct, Mr. Owen?
Yes, sir.
Okay, all right, Mr. Owens, today, we will have speaking on your behalf, Mr. Andrew Hunley from the Louisiana Parole Project and Miss Connie Fitzgerald, your sister. We will get to them at the proper time. Also in opposition, we got Shatanya Keener, victim's daughter, and Sky Mitchell, victim's daughter. We will also have them speak at the appropriate time. So right now, Mr. Owen, tell me, what did you do to get yourself put in prison? And why do you think you should get out today?
Well, I killed my wife. I shot my wife and I killed my wife. And I'm terribly sorry for that. It happened and I never, God knows what I put people through, only knows. But I am a changed man now. I work for the community around David Wade here. I'm a facilitator. AANA. I'm a recovering addict, and I do everything possible. I try to help the elder and push them around in the wheelchairs if they needed to get someone. And I know that I am a changed man. That I work for the better.
Okay. First, we're going to hear for those that are in favor of you getting out. Mr. Andrew Hunley of the Louisiana Parole Project.
Good morning, Andrew Hunley, appearing on behalf of Louisiana Parole Project today to confirm that if this board were to grant Owen parole, that our organization accepts him as a client in our reentry program. That would include housing, employment services, mental health services, and all other wraparound services. We specifically commit, while he would be a long-term client of our program, that we would work with him on ensuring that he works towards continued sobriety and give him the resources he needs to make sure that he's successful upon release. We've come to this decision based on his programming and institutional record, and I stand by in case the board has any questions about his reentry plan. Thank you.
Thank you, Mr. Hunley. Okay, now we'll hear from Miss Connie Fitzgerald, your sister. Miss Fitzgerald.
Yes, I'm here.
Okay, Mr. Fitzgerald, what you want us to know about your brother?
I just wanted to let y'all know that Owen has made a great change from 23 years ago. He has done classes. He's a totally different man. He teaches and he leads the people that he's in jail with, and they look up on Owen. I know I visited him and talked to him. He's a totally different man than what he was. I'm a little nervous, but Owen is top programs, and Owen is a changed man. He is totally different than what he was 23 years ago. He's like a totally different man. And he has a place he can come home to. And my mother, thank you.
No, go ahead. What do you want else to say? I didn't mean to cut you off.
I'm sorry. My mother is here also. She was on Speak Up on Owen's behalf also. Carol Robertson.
Okay, yeah, she can speak. We only had two so far.
Okay.
Put her on, please.
Okay, yes, sir.
Hello.
Yes.
I wanted to say that Owen has a home with me, and I have visited him often and watched him grow and grow into a better man. He's real proud of the men that he teaches. They're young guys, and he tries to show them that there's a different way to live, that to not go back to their old ways that they were back in, that they can be sober and have a better life. And he's real proud of the ones that have graduated through his class. And Owen has a home with me. And it's more than having a home with me. I need Owen to come home. I own property here. We don't live in Vivian. We live outside of Vivian in a rural area. We live on the south side of Black Bayou. And it would be good to have him here with me. I'm legally blind now, and I have 2 other children that also are looking forward to him being home. I lost a daughter May 31st. She had 36 years of multiple sclerosis. And Owen has lost a loving sister, a real sweet girl. And the family needs Owen. I have a home here that will be his. I'm leaving my home to him. I wrote a will saying so, that he'll always have a home. He has a promise of a job through a relative that has an oil company, that he said he would put Owen to work, that Owen could work for him anytime. He'd make a way for him. So we're looking forward to Owen being able to come home and be a productive citizen. And I know he will be.
Okay, thank you, ma'am. All right, now we're gonna go.
Thank you.
Those two are opposed. Miss Shatanya Keener. Keener,
I'm here.
okay, tell us what you want us to know.
I just have some questions that I'd like to have answered, if that's okay, from him.
You can't question him. You can only talk to the board. I ask us questions. I'm sorry.
Okay, so Mama's been gone for 23 years. Why is he just now admitting what he's done? Why didn't he do that a long time ago? We have sat here and we have suffered with no closure as to what happened that day. Now I got to reroute my whole mind now. We don't feel the need that I don't think he's changed. I really don't. I mean, I just think Mama's not coming back. So why should he be out walking the streets? Why should he be out living his life when she's not here anymore? Our family's here. Her brother is here. And we feel like he hasn't served even half of his time yet. The classes and the things that he's taken, that's in prison. That's what he's doing there. What's it going to be like when he gets out? Is he going to go back to doing what he was doing before? We just don't feel like he's changed, man.
Yes, ma'am. Mr. Barra, one of our members has a question for you, ma'am.
Okay.
What is your relation to Owen?
Owen was married to my mother.
So you stepfather?
Yes.
Thank you. Okay. Once again, thank you.
Yes, sir.
Okay, and Ms. Sky Mitchell.
Yes, sir.
Okay, Ms. Mitchell, tell us what you want us to know.
So I was a kid. And a lot of my childhood, I don't remember. Because it was bad, because of owing you. But there's one thing I do remember. And that's the day he killed my mama. And I remember it like it was yesterday. And he sat in that jail for 23 years. And not once did he admit that he done it. He made every excuse in the book. as to what happened. But 2 years ago, when he sat in front of this parole board and lied again, they told him, you didn't, a jury of your peers found you guilty. And for you to come here and not even admit it is why we're keeping you here. And when I wrote in my letter, I wrote to you months ago and told you this is exactly what he was going to do, that he was going to tell this board exactly what you thought you wanted to hear, the admittance of guilt, and that you were going to make him, let him walk a free man. And I know that his mama and his sister and whoever else is listening, he's got nieces and nephews that were also kids when it happened. And I love them, and I'll always love them. And I know that they love their Uncle Owen here. And I don't blame them for that. And I don't hate this man, because that woman right there in that camera told me the day that he shot her that I can't live with hate in my heart. And I thank her for that, because I forgave him 23 years ago. And I have not carried that hate with me. And I have lived a wonderful life. I have 2 beautiful kids and a beautiful family. And the way that I look at that is a blessing, because we lived a terrible life with that man. Things that we couldn't even speak about during the trial because they had nothing to do with the murder. But the day it happened, we got taken out of that life. We didn't have to watch him beat my mama anymore. We didn't have to help him cook dope. We didn't have to pop pills. We didn't have to smell the ammonia burning our nose from all the gas that he'd stolen. We didn't have to worry when the next time the cops was going to come to our house. We lived a great life because of my sister. And I take that as a blessing. And I use that as my testimony. And I don't hate this man. And I don't want him to sit in jail because I hate him. He deserves to sit in jail, because like he just admitted, he killed my mama. And 23 years ago, that judge said 40 years. And at the least, that's what he needs to serve, because his second chance is not with this free world. His second chance is with the good Lord above. And I do pray for him. And I do pray that he prays for his own forgiveness. But do I believe he deserves to walk free? Absolutely not. And for his mama to say he has a home to come home to, the Gator Hole is no home. It is no place for anyone. It is just as bad now as it was 23 years ago when we lived there and he took my mama. The drugs, the thieving, the comings and goings. No, I don't live there. It's a very small town. People know, people talk. There's a lot of that community that never wants to see Owen come back and walk those streets. And while I feel for his mama, because I know she didn't pull the trigger either, she's got 2 other kids that can help her. She's got grandkids, grown grandkids that can help her. She doesn't need him walking the streets to help her. So no, I don't feel like he needs to be released.
Thank you, Ms. Mitchell. We appreciate you coming on today. Okay, your case has been assigned to Ms. Ledoux, so she will lead you in the questioning. Ms. Ledoux.
Mr. Robertson, what was the most impactful program that you've taken since you've been incarcerated?
Took anger management, victim awareness, living in violence, re-entry. I've been in a helpers group. I'm an AANA 12-step program, facilitator. I've been
Those
pretty
are
much,
very good programs. What did you learn from victim awareness?
I learned that I know that the victim they suffer. I really do. I've suffered. It ain't a day that goes by that I don't go think about what happened. And it breaks my heart knowing that what I can only imagine what they went through. You know, I'm a recovery. It's hard for me to say that wasn't there, but I know that they suffered, that they went through, and I feel their pain. I understand their pain.
So when did you finally accept responsibility for your crime?
I realized that it would be best for me to, I know that I lied. I was scared of the way I was treated when I was arrested. I lied, then I lied to cover up a lie. Then I knew that once I went to trial, when I got on the stand to tell the truth, and that's what I did. And I was found guilty of manslaughter. I did kill my wife. I did, and I'm truly sorry for what happened. And God, if I could turn back time, I would.
So what were you initially charged with? What were you initially charged with?
Was charged with a second-degree murder.
Okay, so this is a plea, agreement. You pled down.
No,
Jury found. Jury
they
found.
found,
Okay.
they found me guilty.
And they sent it to manslaughter. Okay. I've read your file and I've listened. I don't have any other questions.
Okay, Mr. Barrow has no questions. I do want to state for the record that we have numerous law enforcement objections. And the DA wrote a letter and he is strongly opposed to you getting out today. Attorney General is opposed. Sheriff Henry Whitehorn is opposed. Honorable James E. Stewart is opposed. That's the district attorney, and the judge, Leon Emanuel, is opposed. I just wanted to state that for the record. Okay, the panel's ready to vote. Okay, Ms. Ledoux, you'll be voting first.
Mr. Robertson, you had a very lengthy criminal history. I'm glad that you're doing things better in prison. I believe in rehabilitation. I believe in making some strides and coming out a better person. Today, though, my vote is going to be to deny based on you've only served very little over half of your sentence. And so with your criminal history and the amount of time served, that's my decision.
And I vote to deny, also based on the law enforcement opposition and the victim opposition.
My vote is going to be the same due to the supervision history, terrible criminal history, and strong law enforcement objection and victim opposition. Good luck to you. Your parole has been denied.
Personally, I wasn't overly surprised by that one. I don't know if you guys were, but I don't think so given the comments. So 2-1 today, denied versus approved. Barbara, thank you for the $5. God is great. Our host is great. Our community, the best. I'm going to reorder that. In the proper order, it should say God is great. Our community is great. Our host is great. Put community second. That's my opinion. But again, thank you for the $5. Very much appreciated. Your support is never goes unnoticed. Let's go back to Judge Boyd.
Oh, yes, thank you. Okay, so Christine was ready for Odyssey to break down. Nobody else was ready. She was ready. Okay.
And thank you as well, Barbara, for gifting that membership. Very generous today, and I appreciate it very much. Just for the record, it is Judge Boyd who's muted at the moment, but we'll hang with her. She should be back on here in a second.
email says, service disruption, immediate network maintenance. All right, so here's my question. And I think that group is so great. They're not the ones who decided on this odyssey. But they're starting the service disruption today immediately. So I don't know if they decided just, we're gonna do maintenance today, or if there was an issue, then it's, hey, we have to do maintenance. Who knows? Okay, thank you. Thank you, Christine.
No problem.
All right, the court is calling 2024 CR 006824 State versus Marco Antonio Marino. Can I have parties announce?
Ashley Jones for the state. Christine Brown on behalf of Marco Antonio Moreno.
And are you Mr. Marino?
Yes, ma'am.
All right, you entered a plea in this case to count one of no contest on May 27th. According to your plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. The state is opposed to your application, and there's restitution. I'm sorry, and there's registration and no contact with the complainant. And there was a PSI that was completed in this case. Have both parties had a chance to review the PSI report?
Yes.
Any objections?
The defense objects on page 3 where restitution is discussed. If you were to look at the plea bargain paperwork, restitution was never something that was brought forward by the state. It was not a term of the agreement. There has also been some concern as to the documentation supporting what is proposed as $4,000 as restitution for certain medical expenses. And I have been in communication with probation officer Gloria Medina yesterday morning, who called me telling me that no documentation was provided to her to substantiate that restitution amount. Yesterday, I filed a motion requesting a restitution hearing. As we all know, Odyssey is down and so is e-filing, so it has yet to be accepted. But that is something that we are requesting if that is something that this court still wants to consider.
All right, well, unless the court receives adequate documentation of restitution, then there's not going to be restitution. So state, do you have any itemized billing?
Your Honor, I have not had a chance to speak with our witnesses regarding the restitution. As defense counsel said, I didn't get the motion for
All right.
restitution,
So if both
I
parties,
just served you, but I understand it has yet to be accepted by the court.
all right, so if both parties are in agreement, we can go forward with the PSI, and with regards to restitution, that can be determined at a later date if there is any restitution.
Yes, Your Honor.
Are
the state
both
will
parties in
agree.
agreement with that?
Yes, we're in agreement.
All right, so the state is opposed. State, do you have any witnesses?
Your Honor, no, we do not have any witnesses, just arguing.
All right, defense, do you have any witnesses?
Yes, we would like to call Stephen Thorne.
All right, Mr. Thorne is by Zoom. Any objection to the witness appearing by Zoom?
Not the state, Your Honor.
And I know you have no objection, counsel, correct?
No.
And Mr. Marino, do you have any objection to the witness appearing by Zoom?
No, ma'am.
All right, Mr. Thorne, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Dr. Stephen Thorne.
All right, you may proceed.
All right. Dr. Thorne, my apologies for addressing you with Mr. Pryor.
Oh, that's okay.
Could you please state your profession for the record?
I am a licensed psychologist in the state of Texas.
And circling back to your profession as a licensed psychologist, where is your place of employment?
I work in a lot of different areas across Texas and other states, but my office is in Austin, Texas.
And so are you self-employed?
Yes, ma'am, I'm in private practice.
And how long have you been in private practice?
I think this August, I think next month will be 23 years, I believe.
And how long have you been a licensed psychologist in the state of Texas?
That same amount. I think in August it'll be 23 years. So.
Are there other states in which you have licenses?
Not full-time, like to a lot of states, if I go testify in those states, I'll have to have like a temporary license. So at any point in time, I may have like temporary license in a couple of different states just when I go testify there, but not full-time.
And what is the extent of the education and training received to obtain your credentials?
I have a bachelor's degree in psychology from Austin College in Sherman, Texas, just about an hour north of Dallas. And I have a PhD in clinical psychology from the University of Texas Southwestern Medical Center at Dallas.
And are these specialized degrees?
Yes, ma'am. I mean, the undergraduate degree is just a general psychology degree, but yes, the doctoral degree is in clinical psychology.
And Dr. Thorne, could you please briefly describe the subject matter of your specialty?
You know, probably at least 95% or more of my practice is forensic in nature, meaning I do evaluations, consulting, testimony, and legal cases. I testify for, the state. I testify for defense attorneys. I do work at the request of judges and probation departments. I do work for the Texas Department of Criminal Justice. So I kind of do evaluations or consulting or testimony for different parties in the legal system. And I do a few other things that don't involve the courts, but the large majority of what I do in some way involves the legal system.
And you mentioned evaluations. Could you specifically mention what kinds and the proportion is being used?
Most of my evaluations are related to sex offenses, either a risk assessment for sentencing purposes, or I do a lot of what they call the civil commitment of sexually violent predator evaluations as well. I also do things like competency and sanity and adult certification, child custody, family law evaluations. But if there's one area that most of my evaluations and testimony is in, it's in sex-related evaluations.
All right, so just to be clear, a topic of your specialty would include sex offender risk assessment.
Yes, ma'am.
And so have you conducted personal examinations or testing of alleged or convicted sex offenders?
I couldn't hear the last part of that. Of what?
Alleged or convicted sex offenders.
Oh, sure. Yes, ma'am.
And how many of these tests, if you can provide a number more or less, how many of these tests or examinations were conducted by yours?
I mean, over 1,000, I maybe 1,500, 2,000, I'll say 1,500 just in be an estimate.
And you mentioned that this was your specialty. Do you teach or lecture in the field of sex offender risk assessment?
Yeah, not teach per se, but yes, I speak at forensic conferences for probation officers, mental health professionals, attorneys, judges, about a number of different forensic topics, including, sexual risk assessments.
And so what publications have you authored in this field of sex offender risk assessment?
I don't do a ton of writing, but I haven't published anything specific to sexual recidivism. My publications about in journal articles or book chapters have been about antisocial personality disorder and psychopathy.
And is that an aspect that you test for when you conduct these risk assessments?
Sure, particularly antisocial personality disorder is one of or antisocial traits in general is one of the primary risk factors we look at in these types of cases.
And Dr. Thorne, I know that you're virtually testifying today. I have sent you what has been pre-marked as Defendant's Exhibit 1, and I did tender a copy of that proposed exhibit to the state for inspection.
Okay.
And without telling me what it is, do you recognize it?
Is one, I believe, is a copy of the report I wrote in this case, or is one my CV? I can't.
There were two attachments.
Yeah, I'm sorry. I'm trying to pull that up. Exhibit 1 is my CV. So this is a copy of kind of our resume, our curriculum vitae.
And is this a fair and accurate depiction of your curriculum vitae or CV?
Yes, ma'am, it appears to be.
At this time, we are offering into evidence state's exhibit, or sorry, defendant's exhibit 1, the curriculum vitae of Dr. Stephen Thorne.
The state would just reject on Thursday, he's here to testify.
All right.
Clarifications.
If I could, and your objection to is what?
Just Thursday, Your Honor.
All right, that objection will be overruled. Defense exhibit number 1 will be admitted.
And Your Honor, pursuant to the Rule 702, the Texas Rules of Evidence, I am tendering Dr. Stephen Thorne as a qualified expert witness in the field of sex offender risk assessment.
He doesn't have an objection.
All right, then that will be granted, and the court will note that he's an expert in the field.
Thank you, Judge. Dr. Thorne, are you familiar with the specific risk assessment tools used in this particular case?
Yes, ma'am.
And how does this particular risk assessment work as it pertains to Mr. Moreno?
Well, they allow us to kind of collect information relating to risk factors. Like, I'll try to give a short answer, but in doing a risk assessment, we look at, are there any factors that the research suggests can increase a individual's risk for sexual recidivism or decrease an individual's risk for sexual recidivism? And so like the RSVP and the static 99R, those are two different factors or two different assessment measures that kind of help organize those risk factors and protective factors so that we can apply them to the person we're evaluating, in this case being Mr. Moreno.
And so are these forms of assessments accepted as reliable in the scientific community?
Sure. I mean, these are assessment measures that I use regardless of which side hires me. They're commonly used, commonly researched in the field. Yeah, they're
Just one moment, please.
Sure.
Sorry. All right, counsel, I'm sorry about that. You may proceed.
No worries. And so now I want to show you what has been pre-marked Evidence Exhibit 2. I have tendered a copy of that exhibit to the state. If you could access that, let me know when you have it ready.
I have it.
And without telling me what it is, do you recognize it?
Yes, ma'am.
And could you identify that exhibit for the record?
A copy of the report I wrote in this case relating to Mr. Moreno.
And when was that report made?
It was last week. I wrote it on June 5th.
You mean July 5th?
July 5th. I'm sorry. July 5th.
No problem. And is this a fair and accurate depiction of the risk assessment report you completed for Mr. Moreno?
Yeah, it sure appears to be. Yes, ma'am.
All right. At this time, we offer into evidence Defendant's Exhibit 2, the sex offender risk assessment report of Dr. Stephen Thorne.
State Attorney Jackson, this say Your Honor.
All right, that objection will be overruled. Defense exhibit number 2 is admitted. Right, you may proceed, counsel.
And so if you could be a little more specific, I know you provided some general details. What methods and principles did you employ in this specific risk assessment?
Well, I performed a clinical interview of Mr. Moreno. I reviewed records relating to the current offense, both the indictment, the offense report, some letters and notes relating to the offense. And then I administered various, psychological or actuarial measures, the adult self-assessment inventory, the MMPI-2 RF, the personal problems checklist for adults, the static 99R, and the RSVP.
And so you had mentioned factors that decrease or increase the likelihood of committing a sex offense in the future. Could you specifically outline what factors were examined with respect to Mr. Moreno?
Well, when looking at, again, what we call like risk factors or protective factors, and looking at some of the risk factors, he has a conviction for a sex offense or for sex offenses committed against, minor children. So that, the age of the age of the victim is important, as that's thought to be a risk factor. He does have a history of non-sexual criminal behavior, and as we referenced earlier, like antisocial traits is a particular risk factor in these types of cases. So his history of non-sexual criminal offenses is relevant to consider as well.
No, I don't want to interrupt, but I did hear you mention something about sexual offenses against children. Just to be clear, were there any, upon reviewing the history of Marco Moreno, were there any past indicators of a criminal history regarding sex offenses against children, aside from this instant case?
Yeah, not prior to this case. So when I was talking about he has a, relating to a conviction in this case for having an underage female victim, but no prior, so no prior sexual offenses.
And so based on your overall assessment, what is your professional opinion, your professional and expert opinion regarding Mr. Moreno's risk?
Well, I should say, I think you'd asked me about factors I considered. I only got to the protective factors, or only got to the risk factors. I did not get to the protective factors, if you want me to address those as well.
Sure.
Okay, the protective factors are he doesn't have any previous convictions for a sex offense. Sex offenders who have a single sentencing occasion for a sex offense are thought to have lower levels of recidivism than those who have multiple sentencing occasions for a sex offense. He doesn't have any male victims. He doesn't have any stranger victims. He doesn't have any victims outside of his family, or any documented victims, I should say. He doesn't appear to have a history of significant psychiatric issues that might increase his risk for sexual deviancy. He seems to at times have had a history of social support and had a history of ability to maintain employment. So those are some of the protective factors that we look at in these types of cases. And then his age. He's currently in an age group where at that age, we expect to see, statistically speaking, we expect to see lower levels of sexual recidivism. So those are some of the protective factors.
And so taking all of these factors into account, what is your assessment regarding Mr. Moreno's risk?
Yeah, I would say he's a relatively low risk for sexual recidivism. And, that's kind of supported again by the protective factors and the risk factors, but also the scoring of the static 99R and the RSVP. So again, my overall opinion is he's presently a low risk for sexual recidivism.
So regarding the possibility of deferred adjudication community supervision, are you in a position to recommend any kinds of conditions that may be helpful to Mr. Moreno?
And Your Honor, I just would object that this is outside of his scope. He was listed as an expert in
sexual predator recidivism rates.
All right, that'll be overruled. I'll let him answer.
I wouldn't have a lot of specific recommendations, about conditions of probation or supervision outside of, I do think sex offender treatment would be appropriate. I think research shows that individuals who successfully complete sex offender treatment, that can lower their risk for recidivism compared to those who are unable to complete a comprehensive sex offender treatment program. So my one, I guess, recommendation relating to that would be that he participate in and successfully complete, a comprehensive sex offender treatment program.
All right, no further questions. Thank you, Dr. Thorne.
Any
Yes, ma'am.
questions?
Briefly, Your Honor. Good afternoon, Dr. Thorne. Can you hear me okay?
I can hear you, but I can't see you, but I can hear you. Yes, ma'am.
Okay, well, my name's Ashley Jones. I'm the prosecutor in this case, and I just had a couple questions regarding to the risk factors that you use to give
Sure.
your opinion.
Yes, ma'am.
It seems that a multitude of them are reliant upon Mr. Moreno's self-disclosure. Would you agree with me on that?
I would, not all. I mean, some are confirmed by the records, but yes, I would agree that some of that is dependent upon his self-report.
Right, and so you would agree with me that Mr. Moreno likely wouldn't admit to any other sexual offenses if there were any other sexual offenses, right?
I don't know that I would use the term likely. I'm not trying to quibble with you. Some people do, some people don't, but I can say I'm not surprised if people don't admit to any undocumented victims. So I hope that makes sense.
It does, thank you. And as a psychologist, you would know that it's hard for kids to speak out about sexual violations that have occurred to them.
Sure. Yes, ma'am.
And I think you mentioned earlier in your testimony that there are no other documented victims, but you're not saying there aren't any other victims out there.
Right. And that's exactly why I try to use that term, documented victims, documented by arrest or conviction. Because sometimes people have victims that don't result in arrest or conviction. So I try to use that specific language for that reason.
And I do believe in your report, you stated that no one factor can accurately predict whether a defendant will commit another sexual offense. Is that correct?
Yes, ma'am. Yes, ma'am.
And so you're not saying that Mr. Moreno wouldn't commit another sexual offense. You're just saying based off his self-disclosures and what you've read, the risk is low.
Yeah, first of all, I would never say that about anybody, that they will or won't commit a sex offense in the future. But yeah, my opinion about low risk is based off, again, not just his self-report, but also information in the offense report, what he's convicted of, and probably most importantly, an application of the research to his particular case. So
yeah, and just going to the procedures used in evaluation, it was a clinical interview with him.
Yes, ma'am.
Okay, an adult assessment, self-assessment, so one that he did, right?
Yes, he kind of checked yes or no to a number of items on that measure.
And then there was this Minnesota multiphasic personality inventory number 2. And I do believe in your report you stated his test results should be interpreted with caution. Is that correct?
Right, correct.
And that would be because there's history of underreporting when the self is underreporting in that test. Is that correct?
Yeah, on that particular test, it wasn't invalid. It wasn't to the point it was invalid, but it did suggest maybe a reluctance to admit certain shortcomings, weaknesses, problem areas. So that's why I, qualified that in the report.
And then the personal problems checklist for adults, that was also completed by Mr. Moreno.
Yes, ma'am.
No further questions, Your Honor.
All right, any other questions?
No further questions for this witness. May he be excused?
Yes, thank you so much for coming, Dr. Thorne.
Thank you, Your Honor. I appreciate it.
Any other witnesses?
Yes, the defense called Vidalia and attendees. Please.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up because the court reporter is taking down everything, okay?
Yes.
All right, if you'll state your name for the record.
Vidalia Resendiz.
All right, does she need, spelling? Yes, please.
It is Hidalia. Last name is Resendiz.
All right, you may proceed, counsel.
Ms. Desmedines, what is your relationship to Marco Moreno? Marco Moreno is my brother. And are you his older sister or younger sister? Older. And how would you describe your relationship with Marco? I would describe it as a really good relationship. And what examples could you give of how you have a really good relationship? We would talk in the phone even if we didn't see each other very often, but even when I lived in Atlanta, Georgia, we would call from time to time. We would just text to see how we were doing. And after we moved here, on weekends, most of the weekends, we would meet up at my mother's house and just to visit, sit there, talk, and just hang out in my mom's house. And so where is your mother's house? She lives in 2618 West Trail. All right, what city? San Antonio. And what is your relationship to the victim in this case? To the victim in this case, she was, I considered her like my step niece. And why would you say step niece? Because I felt like sometimes she opened up to me and I saw her like that, like a niece. All right. And so how often would you interact with this family, including your brother and the victim in this case? From time to time, maybe once a month. My brother was more often, and as well as his children, but with the victim in this case would be from time to time, every now and then, even when I lived in Georgia, sometimes I would text her.
I'm sorry, could you keep your voice up just a little bit for me?
Yes, ma'am.
All right, you may proceed.
Yes. And so, what was the extent of your interactions with the victim and her family while this case was pending? Well, I went to visit probably twice. Once, it was almost after my brother Marco Moreno was arrested. And what were your observations during those times? My observations, well, within the home was filthy. The home was filthy and. How would you describe that? Affect relevance. Judge, may I respond?
Yes.
So the Article 42A102 of the Texas Code of Criminal Procedure allows a judge to place a defendant on deferred adjudication for this offense. But what must be considered is that this would be in the best interest of the victim. We are going into a discussion that we believe would assist the court in making that determination.
All right, the objection would be overruled.
Yes, the home was dirty. It was messy. That's what I noticed. What do you mean by dirty or messy? There was things all over the place, including the floor, the table. There was hardly anywhere to sit. And what do you mean by hardly anywhere to sit? There was things all over the place, all over, like items. How many children were in that home? From what I saw, it was my niece and nephew. How old are they? 6 and 9. And who else was in that home the last time you were there? There was a man that opened the door, or he opened the door, and then when he saw us, he shut the door, immediately shut the door. And so I don't know, I've never seen him. So after that interaction with that man, what happened? After that interaction, well, he shut the door and then we continued knocking until the victim's mother came to open the door. All right. And then without saying names, how did that interaction proceed from there? Well, that interaction proceeded where well, what did you learn from that interaction? The victim's mother was saying that objection to saying
Sustain.
she was saying
You're not allowed to repeat what other people have said. All right, so when either party makes an objection, I'm going to make a ruling. If you don't understand my ruling, just let me know. You can say, do I still continue to answer or not? Okay. No, no problem. So in that situation, you're not allowed to say what anyone said. You understand?
Yes.
All right, so that objection will be sustained.
And so without going into what anyone has said or told you, what was your understanding of the family dynamics based on your observations and interactions?
The family dynamics to me is, it's, I don't feel like it's a good situation there.
Why is it not a good situation there?
Based from what I saw, I feel that no children should be staying in a filthy house.
And to your knowledge, who was supervising these children, to include the victim and the
To my knowledge, a lot of times the victim was supervising the children.
And how old is the victim?
The victim, now she is 16.
How old was she when you had personal knowledge or observations of this?
She must have been about 14, 15 years old.
And just to be clear, how long have you known the victim?
It has been probably 6 to 7 years.
Right. And so I want to talk more about your brother. What assurances could you provide this court if his application for deferred adjudication were approved that he has a foundation to be successful on deferred adjudication?
Well, I would, on my behalf, I would call him and go to where he would be staying. I would call him and make sure that he is following up and keep track of his, if he has any appointments with his officers or anything, I would keep up with that, find out, put it on my calendar if I have to, give him a call. And if I'm able to, I'll take him myself because I want him to succeed and I know he will.
Okay.
And where would he be staying if he were released?
He will be staying at my mother's house at 2618 Fitzgerald, here in San Antonio.
And what more would you like the court to know with regard to his application?
I know he is, I know he will, I know he's learned his lesson. I know he's a hard worker. And he has a lot of support at home. He does. He has a lot of support. We will all keep an eye on them and make sure that he follows through. And I know he will.
Nothing further.
All right, state.
Yes, ma'am.
Good afternoon, good morning.
Good morning.
Ms. Endes. So you're the defendant's sister?
Yes, ma'am.
Okay. And his older sister, do you have any children of your own?
Yes, I do.
What are their ages?
They range anywhere from 22 to 36, 37, sorry.
Do you have any grandchildren?
Yes, I do. I have 6 grandchildren, 1 great grandchild.
Congratulations. What are the age ranges for the 6 grandchildren?
The ages are almost a 2-year-old all the way to a 21-year-old.
And what about your great grandchild?
He's 3.
3?
Yes.
And I think you said he's a little boy.
Yes.
All right. And I want to talk about you're here today. How do you know about, or what do you know of this offense? What do you think happened?
What do I think happened? I think I'm gonna be 100% honest. I feel like they wanted to get him out of the house so he doesn't have contact with the children.
So you don't believe he did this at all?
No.
And so then you, not believing that he did this at all, you wouldn't have any concerns about bringing your children, grandchildren,
No.
great-grandchild around him? Okay. No further questions, Your Honor?
All right. Any other questions?
Yes, just briefly. Sure. And Mr. Endes, I understand that this may be a very difficult question for me to ask, but it relates to what the state has asked you. As it pertains to child abuse and the topic of child sexual abuse, what personal experiences have you had?
Objection to relevance, Your Honor.
Overruled.
Can I proceed?
Yes, you can proceed.
I have personally, my oldest daughter, when she was 13, she was beat and abused, sexually abused. So for me, if I knew my brother was guilty, I would have supported him because I know how that feels.
All right. So here's the thing. I want to thank you so much for giving me some insight into your brother. And I understand that sometimes when relatives come to testify, people want them to say that they believe this is true, right? And if you don't believe it's true, that's fine. And I'm not going to hold it against your brother that you don't believe it's true.
Right.
So I want you to know that when people come and testify, all I want them to do is tell the truth.
Yes.
And when you tell the truth, it doesn't negatively impact your brother. So the fact that you don't believe that he didn't commit this offense, that's not going to negatively impact him. I'm just trying to get some insight about him through the witnesses that are called so that I can make an appropriate decision in this case. Okay?
Yes, ma'am.
All right. Is there anything else?
Nothing further.
Anything else? All right. Thank you so much for coming in. All right. Next witness.
Yes, at this time, the defense calls Juan Moreno to testify.
All right. Could we let me just take a short recess so I can take up a couple of more cases and then I'll continue.
Thank you.
All right. Thank you so much.
Okay, this does continue. We're in the Wayback Machine a little bit, but I have to call it a day. So I am dropping a link in the chat right now to this stream from Judge Boyd. And if you want to continue with this on your own, just use that link and you can go right over there and check it out. But we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. I do appreciate all of you. It was a glitchy, weird kind of day in court, but I still had fun, and I hope you did as well. And I'm going to go work my rear end off today because I have a massive amount of things to do. But I look forward to seeing you all tomorrow. In the meantime, make yourselves a great day today and take care. God bless.